I'm Terry Gerstein. I'm the director of the NYU Wagner Labor Initiative. And I'll start out just giving a little bit of background and some framing on our conversation today and give you the roadmap of what we're going to do, and then turn it over to Josh Bivens for some framing conversation. So as I said, I direct the NYU Wagner Labor Initiative, which advocates for and accelerates government's role in safeguarding and advancing workers' rights, helping government work better for workers by serving as a hub of analysis, research, and implementation guidance, as well as idea generation and dissemination. And so this involves, helping improve and expand enforcement, especially at the state and local level, conducting research and scholarship on policy and enforcement and implementation, helping raise awareness of the public and policymakers about worker issues and labor issues, and then hosting events and helping build community, having convenings like this one. I am so excited for our conversation today about the critical relationship between antitrust and worker power and workers' rights. There is so much exciting movement happening in this area. Some of the questions, as we noted on the flyer, some of the questions we'll be discussing today are, what does the next phase of the antitrust reform agenda look like in relation to labor issues? How can anti-monopoly be used to address the great power disparity between corporate power and worker power? What legal and policy levers can be used to advance workers' rights and address the needs of working people? And what's the role of state and local legislation and enforcement in this area? So what we're going to do today, first, we'll have Josh Bivens, who is the chief economist at the Economic Policy Institute, and he'll offer some framing comments. Then we have two phenomenal keynote speakers. We have New York State Senator Mike Gianaris, and we have FTC Commissioner Alvaro Bedoya with us today. And then we're going to have our keynote speakers, and then we're going to have our first panel. We'll have a brief break, have our second panel, and then some closing thoughts. So this is going to be a really great conversation today. I'm really excited about it. It's going to be about theory and practice and enforcement and legislation. And above all, we really hope that the conversation today sparks, yes, a lot of ideas, but also concrete action that will make working people's lives meaningfully better in the United States. So I'm going to turn it over. I also want to thank all of the co-sponsors and co-hosts. There are a number of organizations that are co-hosting, and I want to make sure to acknowledge and thank all of them who have been involved. So I'm going to turn it over to Josh right now for some framing comments.
So yeah, let me just say it's great to be at this event. Thanks so much for including us, and it's an honor for EPI to be a co-sponsor of it. I'll just say I work at an institute, EPI, that is positively obsessed over the loss of bargaining power and leverage in labor markets experienced by typical workers over the past generation of economic life. We think these losses are the most important drivers of all sorts of bad economic outcomes in the U.S. economy. It has generated inequality. That inequality, in turn, has played a big role in dragging down aggregate rates of growth, and the cheapening of labor that it has spurred has played a big role in the stagnation of productivity growth over the past 30 years. Like, why innovate that hard to cut costs when your biggest cost, labor, has already been cheapened so much by policy actions? And so given the importance of the loss of typical workers' leverage and bargaining power, sorry. Yeah, thank you. Phone in one hand and
So they can see you.
got it. Thank you. Sorry. So given the importance of this loss of leverage and bargaining power, our sense is the more tools we have to fight it in the policy toolkit, the better. And the drive in recent years to really recruit antitrust and competition policy as one of these tools, we think is a really great innovation. There have already been big wins posted in this intersection space. To my mind, the non-compete rule, which has been a very big deal. So I'm just going to say a couple more words about why the labor market should continue to be a real focus of antitrust and competition policy, and then maybe a word or two on how competition should be thought of in labor markets particularly. So first, on why continue to focus on labor markets, I would say the way I see it, antitrust and competition policy is at its heart about restraining the abuse of excess corporate power that inflicts harms on communities. There's a traditional school of thought that says only the power that is exercised in product markets and which manifests itself as sort of excess product market price growth should be the purview of these policymakers. We know that's just wrong. That should be consigned to the past, and for a couple of reasons. I mean, first, in recent decades, like up until the onset of the pandemic, many of the mega corporations that clearly exercise huge amounts of power in the US economy, they didn't tend to exercise it by raising prices really fast in the product market. Instead, lots of this power was leveraged backwards through their own supply chains, squeezing their own workers and then their suppliers, which mostly means wages of workers who work in their supplier industries. This isn't universally true. In the healthcare sector, for example, growing market concentration really did mostly manifest itself as really fast price growth, and that was how it inflicted harm on communities. Which, by the way, I was just going to say another reason to be really happy about some recent antitrust and competition policy moves. The FTC's moves in the healthcare arena have been most welcome. But for decades, it was kind of mostly true. The path to increased profitability was mostly pursued through, I'd say, wage suppression, not price gouging. Just one example, in the first 5 years of recovery after the Great Recession of 2008, the labor share of income in the corporate sector, sort of what share of income generated in that sector ended up in as workers' pay rather than profits, fell by 5 percentage points. I don't know if that sounds big, but it's about $800 billion in today's dollars that was transferred from workers to owners of corporations. But over that period, this didn't happen through really rapid price growth. If you look at sort of inflation in the corporate sector over that time, it ran at an average about 1.7% over that whole time period. Unit labor costs obviously rose barely over a half percentage point. So wage suppression in labor markets really was the short route to profitability in that time. You know, the conditions in the post-pandemic recovery made the path to profitability run more through raising prices really quickly. We've all come through this era. I think there's a number of reasons of that. We can talk about it, but basically, between the big demand shifts caused by the pandemic and supply chain snarling and the fact that we actually did tighten labor markets up very quickly this time, admirably, through a really rapid fiscal response to the pandemic recession, basically it meant that when corporations looked, what is the short route to profitability? They decided higher prices, not wage suppression. This is what happened. In the 4 years since the pre-pandemic business cycle peak, that labor share of income in the corporate sector, it's fallen by about 2.5 percentage points. That's a lot of money. But in those quarters, prices in the corporate sector actually ran at an average inflation rate of about 4%. So more than twice as fast as after the Great Recession, more than twice as much as what the Fed says is their comfortable target. And this even includes the near deflation year of 2020 in there. So basically, if you look over the past 4 years, the route to profitability that corporations took was price growth, not wage suppression as much. But there are mostly two manifestations of the same underlying problem, excess corporate power. Why in recent decades has it been more often manifested in labor market wage suppression rather than sort of apparent price gouging? I think it's a really good question. I think part of the answer is just going to be my final thought. Unbalanced power is just the norm in capitalist labor markets. And importantly, it doesn't require bigness. It doesn't require a bunch of firms forming together and making themselves big. And it doesn't really require much in the way of barriers to entry. And so if it's more often going to be the norm and it doesn't require those things, it just strikes me that it is often going to be the shortest route to profitability for these corporations. So in product markets, if you have a bunch of firms and you have relatively low barriers to entry, you really likely will probably get close to something like fairish product market prices. But many employers and relatively free entry are not sufficient to guarantee good outcomes in the labor market. Capitalist labor markets, by their very nature, are unbalanced. Employers have an upper hand whenever they have the chance to negotiate with individual workers, or more likely refuse to negotiate, just post take it or leave it wage offers, which is really the norm. This sort of endemic excess employer power was held in check in large swaths of the US labor market for decades after World War II, through a bunch of countervailing institutions that we all know. Labor unions were stronger. Federal minimum wage was higher and it was raised a lot more frequently. Full employment was much more the norm. As all these sources of countervailing power have been eroded, the excess employer power in labor markets has just reasserted itself with a vengeance. And of course, capital owners and corporate managers haven't just been content to strip away these sort of bulwarks of countervailing power. They've also been working hard to construct new institutional tools and practices to claim ever bigger share of the economy's incomes, whether it's outright collusion in labor markets, no poaching agreements, non-competes, mandatory arbitration. Everyone knows the list. So I'd say antitrust and competition policymakers should be thinking as hard about how to block these intrusions into labor markets as they think about product market power. Just sum up, many of our economy's worst problems come from unbalanced power in labor markets. And if you have any group of policymakers that has a chance to address that and doesn't take the opportunity, they're just not doing their job right. And so that's why I think today's convening is so valuable. This has just become a growing recognition with sort of growing intellectual firepower behind it. And because it's so valuable, I'll end now and say, let's get to the substance of the conference. Thanks so much.
Thanks so much, Josh, for those framing remarks and for really putting it in those stark terms of in relation to the power imbalance between corporate power and worker power. So now we have two amazing keynote speakers. I'm really excited to hear from each of them. First, we have Senator Michael Gianaris, who's the Deputy Majority Leader of the New York State Senate, representing Western Queens. He was born and raised in Astoria and still lives there. And I'll take some of the language from his bio on his website. I think will really resonate with a lot of us in this room. And it says that he is guided by the principle that the playing field between everyday New Yorkers and powerful interests is grossly skewed in favor of the wealthy. And so with that sort of animating vision, he's been a champion for tenants' rights, for voting reforms, and for workers' rights, and many other issues. Some of his accomplishments: he wrote legislation barring discrimination based on immigration status, secured funding for community groups providing legal services to immigrants in need. In 2019, he passed the most comprehensive tenant protections in New York State history, as well as that same year, the most comprehensive bail reform legislation in the country. And he also wrote legislation to help register more New Yorkers to vote. In relation to the subject that we're talking about today, he is really a leader within the state and nationally. He's the chief sponsor of the 21st Century Antitrust Act, which I was going to say if it's passed, but I'd rather say when it's passed, will be the most important change to antitrust law at any level of government in a generation. So Senator Gianaris, thank you so much for joining us, and we're really eager to hear your thoughts.
Thank you. Good afternoon.
So we see your face and not just your.
Okay, is that good?
Hold it back a little. There.
Just stand back. Okay. Anyway, enjoy my chin, those of you who are watching. I appreciate the introduction. One caveat is the most comprehensive tenant protections New York State had were passed in 2019, and then we just passed even more comprehensive tenant protections about 3 weeks ago. So. We now have something called good cause eviction protections in New York, which has never been the case before. So that's not why we're here, though. We're here to talk about market power and the effect on workers and building workers' power. I want to start by talking about capitalism. Capitalism is, you got to hand it to it. It's ruthlessly and unapologetically efficient at its goal. And its goal is to make money for the people that already have money. And they're very good at it. And part of the problem, I think, in today's society is that we have drifted away from government's role as it relates to capital. Okay, capitalism, yes, we support capitalism. It does some good things. It creates jobs. It's innovative. All of the good aspects of what it does do not outweigh the negative aspects of it. And what we're supposed to do with that in a capitalistic society is regulate it. And that's government's job. And unfortunately, we have drifted far away from doing that because of the philosophical direction this country's taken over the last several decades. Like the previous speaker mentioned, it was the post-World War II era. You had a lot of worker strength in this country. The middle class was stronger than it's ever been. And then I think the damage done to working people in this country from the politics of the 1980s are not fully appreciated and are still something we need to unravel. I was on Squawk Box a little while back, and we were talking about tax policy. And of course, their position was the hosts that you can't raise taxes on anybody because that's bad. And I said something that I think made Joe Kernan's head explode on the screen. I said, Ronald Reagan was wrong. You guys got to figure that out at some point and help us build a better society for all Americans, or else we're heading in a very dangerous place. And so that's, I think, where we've lost our way is you look at something like antitrust policy, which is what we're here to talk about. It's been a century since the laws really were created and have been looked at. And what has happened in the last 40 years is it has been chopped up. It has been whittled away. Courts have made it harder to bring enforcement actions. The economy itself has morphed into something that those laws are not really applicable to. And what we have tried to do here in Europe now is come up with a proposal to change that, which I'll get to in a moment. But I want to talk about the dangers of antitrust policy. We're here at an academic institution. It's a very intellectual concept, I suppose, but it has real world implications for people. And historically, antitrust policy was built around, and I think this was also mentioned by the previous speaker, was built around making sure prices are not overly inflated, not even to make sure that the market is competitive for smaller and middle-sized businesses, simply just make sure that there's no impact on the consumer that is detrimental. And that's missing a whole big aspect of the problems with the consolidation market power that we're now seeing. The examples are plentiful. I'll talk about my favorite company, Amazon. For those of you that don't know, I was the person who had about whom the most entries were listed in Amazon's HQ2 burn book because I was HQ2 was supposed to be in my district, but we stopped it. So as you all know, as it turns out now, Virginia's not getting it either because they stopped building, they're not paring back, they fired people in the last year, never mind not creating jobs. So I think history has proven us right on that one. But the fact is, here's a company that has obtained unimaginable power over not just the marketplace, but the world, over government, as we saw in that example and others, right? They sat here and told the entire country, you come to us and tell us how much you're giving us for us to even think about placing an office in your city. It was outrageous. It was outrageous. And of course, things being what they are, everyone bent over backwards to accommodate them. And those that won are now suffering the consequences of that. But it doesn't stop there. They have power over our politics. Seattle City Council years ago dared to suggest that they fund a program to help people who are unhoused in Seattle. And Amazon was so offended by that, I guess they spent billions of dollars trying to beat city council people in Seattle in elections. It's just unfathomable. So when you talk about the power that they had, yes, they certainly had power over their competitors, over their workers, the way they'll talk about, but over every aspect of our lives in a way that if we believe in some of the foundational principles of our democracy, separation of powers, balance of power amongst different entities, we just lost our way at the altar of the big, powerful corporation. It's happened before, and government reacted the way it was supposed to. We had antitrust laws that took on the robber barons of a century, but I guess we are. I was going to say no one is really focusing on it now, but we are. And this is a growing movement that is starting to pay attention to not just the consequences for prices, although that's real also, but the consequences for small businesses, the consequences for workers throughout this country. Because if you're consolidating power over the market, you're also consolidating power over the workforce. New York is a big place with a diverse economy, but you go some other places in the country, and Amazon's it. You want a job? You got to go apply to the local warehouse and hope that they give you a job. And when that happens, they're dictating salaries, they're dictating benefits, they're dictating hours, and you don't, as a potential employee, you don't have the opportunity to say, well, I'm going to go somewhere else and work over here because they're offering me a better deal. The more concentrated the power is, the more concentrated the market is, the less opportunity there is for a worker to leverage their position and bargain effectively. And so that is why what we're talking about today is so critically important, and why it's necessary to take our antitrust laws and pivot them to something that is more impactful in the 21st century, which is why we call my legislation the 21st Century Antitrust Act, because we're trying to do that. The laws haven't been updated. Penalties in New York. New York has always had its own and parallel antitrust laws, very similar to the federal laws, but we have had the opportunity to bring enforcement actions as a state in addition to waiting for instance, the federal government to do so. So that has been the history of New York's approach to this, and New York being so economically powerful and important, what we do impacts the rest of the country and indeed the world. And so we're trying now to say, we're trying to revolutionize the way we think about antitrust enforcement. And we've taken aspects of other jurisdictions that do this, we think much more effectively, particularly in Europe. They have a standard that is very different from the way the US enforces antitrust. They have something called abuse of dominance as the marker for determining when the law has been violated. So we are proposing adopting that here in New York. The penalties in our New York antitrust laws haven't been updated in half a century. So we're at the point where enforcement of the non-play act, which is what we call it, is ineffective because when you're talking about $1 million penalty, these companies write that off in a couple minutes without thinking twice about it. So we would actually increase that 100-fold and make the penalties $100 million for violating the act. We would have a pre-merger process that would require the involvement of organized labor when the Attorney General is evaluating whether to approve a proposed merger or not. They would now, they do consider it. I think our Attorney General is doing a great job. In fact, she has been helpful in drafting the legislation, but they now will consult or think about the effect on labor. We would require labor to be at the table as that analysis is ongoing, and would really enhance the power of organized labor in the conversation about when a proposed merger should in fact happen. And I think perhaps most importantly, we would adopt a standard for monopsony, which is, I'm sure something many of you are familiar with, which is power not just over the marketplace and the products that get sold, but power over the workforce. So we say power as a seller is the power over the marketplace, power as a buyer, purchaser of employment, so to speak, is the part we would add, which would, for the first time, allow an evaluation of the consequences on a workforce of over a concentration of power. So the example I gave earlier, if you have a situation where you have one or two employers in a particular market and they are asserting themselves to the detriment of their workforce, that is something that regulators can use in an enforcement action. So predictably, usual suspects are suggesting that we are destroying the country, tearing it apart at the seams, doing things that would lead to people fleeing New York. That's my favorite excuse for everything we propose. Everyone's going to leave New York. What's interesting is the last year or so, we finally have some data showing the truth, which is, I mean, New York has lost relative population. You see that because our members of Congress have decreased, right? That's true enough. But what's really happening is it's not the millionaires and billionaires who are leaving. I'm sure some of them are. They end up getting replaced. In fact, we have more millionaires today than we had before COVID. But what's happening is working people are leaving because they can't afford to live here. And they're not getting the kind of help that they need to survive and live a good life here in New York. So we need to refocus that conversation as well. But we're facing a mountain of opposition. Events like this are so important to help us communicate what it is we're trying to do and why, because it's a very, as I mentioned at the outset, a very academic issue in some ways. And so my colleagues who are busy trying to get housing for their constituents and do some of the things that we do on a day-to-day basis and making the lives of the people they represent better, I'm not often sitting here thinking about, that was Amazon trying to bust it. Stop speaking. But we have some work to do to educate people about the importance of this approach. And you mentioned you want to see it pass. The Senate has passed this proposal a couple times going now. We're trying to get to the Assembly to join us this year, and we have some good prospects in terms of sponsorship and should be hearing about that shortly, but we're excited about where this goes. We don't have a ton of time this year. We have about a month left in our session, so I'm hoping to be able to get progress the other house, but we're not going to let it go. We need your help to keep the conversation going and make it clear that this is something that is important. Yes, for workers, but for the entire country, because without a vibrant middle class, this country gets very divided, very unequal, very quickly. And I think, I fear that we already reached a breaking point as it relates to that, because it's been getting worse and worse for about a half a century now. So it's our job to turn that around. And I know we can do it if we all roll up our sleeves and work hard. So thank you for giving me a few moments and enjoy the rest of the day.
Thank you so much, Senator Gianaris, for those comments and for your leadership in this space. And I just wanted to note also the connection that you mentioned at the end about the relationship of all of this to democracy. I think is something that is very salient and that should be sort of part of our thinking as we think about all of this. And I'll also share a little bit of a personal note, which is I spent many years enforcing New York's labor laws in the New York Attorney General's office, New York State Department of Labor. And I remember the first time I learned about sort of how started thinking about how antitrust affects workers. And it was like, really a light bulb went off because I was so used to thinking about like all we could possibly do was get workers the minimum, the bare floor of what the laws allow them, what the laws require, but applying antitrust to like addressing all of these issues you're talking about really is one way that government can play a role in not just like enforcing the bare minimum, but actually improving people's standards and setting the landscape and setting the context so that we can actually have higher wages for people and a different distribution of money and power between corporations and workers. So thank you so much for your leadership in this area. And, there's not that much time left in the session, but we're all pulling for you. So our next speaker is FTC Commissioner Alvaro Bedoya. And I have there we go. He was sworn in 2022 as a commissioner of the Federal Trade Commission. Before that, he was the founding director of the Center on Privacy and Technology at Georgetown University Law Center, where he was also a visiting professor of law. He's been influential in research and policy at the intersection of privacy and civil rights, and co-authored a 2016 report on the use of facial recognition by law enforcement and the risks that it poses to privacy, civil liberties, and civil rights. Previously, he served as the first chief counsel to the Senate Judiciary Subcommittee on Privacy, Technology, and the Law after its founding in 2011. And he was also chief counsel to former Senator Al Franken of Minnesota. On our subject that we're talking about today, antitrust and labor and workers' rights and how they all overlap, Commissioner Bedoya has really been a leading voice nationally on these issues and a leading voice advocating for incorporating worker issues into the world of antitrust. Many of you are likely familiar with several recent speeches that he gave on this issue that really provided intellectual leadership, thought leadership on these issues and sort of laid out the case in a very compelling way. One of them, for example, was about worker misclassification as a potential unfair method of competition. And another was about incorporating worker issues in merger analysis. So again, we are so lucky to have two of the national leaders on these issues with us today. And I'm so excited to hear what you have to say and so glad you're here with us. Thank you.
Thank you so much, Terry. Significantly shorter than Senator Gianaris, so let me make sure. I think it's okay right here. That was a very generous introduction. Thank you. I want to say that it's not just me, it's a whole team. Catherine Sanchez is here in the audience. Max Miller's at home. Sunil Stephen, Dahlia Ratrinsky, our amazing economist, Brett Wendling, all help me understand what I don't, which was a lot, now a little less. So thank you. I want to thank Josh, the Economic Policy Institute, along with the Wagner Labor Initiative and every other co-host of this event for having me here. I should say really quickly, I am speaking just for myself. I'm not speaking for the commission as a whole, any of my colleagues, any staff at the commission. With all of those thanks and disclaimers out of the way, I'd actually love to start by looking back for a really important reminder of why it is so important that antitrust enforcers focus on labor. Because well, most of recent memory, people have thought of labor and antitrust as quite separate. Back in 1890, there was no question that they were closely connected. The people who passed our nation's first antitrust law wanted that law to stop what the trusts were doing to labor. And at the most basic level, they wanted to be sure that antitrust could not be used to stop labor organizing. If you read the floor debates from 1890, this is exactly what you'll hear. You'll hear Senator John Sherman talking about how trusts could command the price of labor without fear of strikes. You'll hear Senator Hoare of Massachusetts say that when we are permitting and even encouraging labor organizing, we're permitting and encouraging what is not only lawful, wise, and profitable, but what's absolutely essential to the existence of the Commonwealth itself. And this is what you'll hear. What you'll see is that Congress amended that first antitrust law, the Sherman Act, not just once, but twice to make sure it couldn't be used to stop labor organizing. And yet that's exactly what happened. The Sherman Act was used to stop longshoremen striking in New Orleans. It was used to stop Pullman company workers who were striking because they were literally going hungry after their wages were cut 25%. The Sherman Act was used to stop a union drive by hatters in Danbury, Connecticut, who were suffering from mercury poisoning. And it wasn't even used to stop the union drive. It was actually used to seize their homes, which were only saved when organized labor around the country donated, I think, an hour of their wages to save those homes. You know, it's astonishing to say it, but it has to be said. Most early antitrust enforcement was not antitrust. It was anti-labor. And it wasn't just labor that was furious about that. Congress was furious about that. This was a complete subversion of their intent that antitrust be used against labor and not at concentrated corporate power, not against the trust. One of my favorite quotes is from a congressman from Wisconsin. During the 1914 debates, he said, "We're aiming at the gigantic trusts and combinations of capital and not at associations of men for the betterment of their conditions." He said, "We are aiming at the dollars and not at men." And so in 1914, Congress passed the Clayton Act to make it crystal clear that antitrust law should not be used to stop organizing. Samuel Gompers called it a Magna Carta for labor. And yet again, the law was used to stop organizing. And this was done most notoriously, in my view, to stop organizing by mine workers who were being paid in worthless scrip, redeemable exclusively at their company store. And yet, unfortunately, antitrust law was used in this way until only recently, despite yet another law, the Norris-LaGuardia Act, that was passed in 1932 to try to stop this. At this stage, I have to reflect personally, I'm a former Hill staffer. So it was my job for about 5 years to help, write and pass laws. And when I look across American law, when I look at intellectual property, environmental law, privacy law, you name it, it is really hard for me to find another area of law that was so completely turned on its head. The trust had power over labor. The law was supposed to curb that power, and instead it was used to curb labor. That could not be clearer. And so, I spent a lot of time thinking about how we return to that original purpose of antitrust. How do we answer Senator Sherman's call to stop combinations that command the price of labor without fear of strikes? And for me, when I think about that question, there's three parts to it. First, I think antitrust enforcers need to do no harm. Congress demanded not once, not twice, but 3 times that antitrust law not be used to stop efforts by the individual unorganized worker to organize. We should interpret that exemption as broad as Congress intended it. Frankly, though, I think that's table stakes. I think if we're going to abide by that original purpose and answer that call, we need to do much more than that. So The second thing I think we need to do is use our broad authority under the FTC Act to protect against unfair methods of competition that can hurt labor. When Congress created the institution I'm a part of now, when Congress created the Federal Trade Commission, they were tired of hair-splitting antitrust analysis, where no matter what, labor loses. And so they empowered us to identify and stop unfair methods of competition that violated the spirit of antitrust law, even when those methods might not check every single box under the Sherman Act or the Clayton Act, and even when the harms that would flow from that conduct had yet to cement, had yet to fully form and start hurting people. The Supreme Court, courts of appeal have repeatedly affirmed our ability to use that authority, particularly to stop conduct that's coercive, collusive, exploitative, and where that conduct changes competitive conditions for workers. And so I think it's incumbent on us to look at the economy, to look at labor markets and see where that is happening. You saw this most recently in our issuance of a final rule to bar almost all non-compete clauses in this country. I think we need to take a hard look at not just non-competes, but also at worker misclassification and vertical restraints under that unfair methods authority as well. I think worker misclassification is a pervasive national scandal. It takes money from law-abiding employers and law-abiding workers and puts it in the pockets of lawbreakers. It dramatically worsens working conditions for workers. And again, it hurts by employers who are playing by the rules. I think law enforcers should consider how it affects competition and bring cases where necessary. So first, I think we need to do no harm. Second, we need to look at our affirmative authority under the FTC Act and apply it to changing conditions in the economy. And third and lastly, I think we need to have a core focus in our merger reviews upon labor and labor markets. So I'm about 2 years in antitrust, and I was a privacy guy, as Terry mentioned. And one of the first things that happens when you start reading about antitrust is you discover all these technical anodyne terms. And sometimes it's really hard to read those terms and see the people that are affected by what they're supposed to describe. And so one of those terms, one of those anodyne technical terms is labor market power. Now, what's labor market power? Loosely speaking, this is a way of looking at an employer's ability to drive down wages, to hurt working conditions without losing their workforce, without losing that control over them. And one way to measure labor market power is to estimate how much less money working people make because of concentration in labor markets and because how hard it is to get a new job and interview for a new job and choose to take it on and get hired. So the Treasury Department recently estimated that Americans lose 2 or 4 paychecks worth of pay every single year because of labor market power. And here's the crazy thing about that estimate, because even if they got it dramatically wrong, even if it's just half of that size, that could be rent for a month. That could be the deductible on a surgery. That could be a down payment on a car that doesn't break down all the time. That is the kind of money that working people lose when combinations command the price of labor without fear of strikes. That's the kind of money that's at stake here. Another one of those anodyne terms is labor monopsony. And I'm not the first to mention it today, but that is a word used to describe what happens when an employer has that labor market power. And I encourage everyone, when you hear that term, labor monopsony, don't think of a number, don't think of a percentage. Think about workers getting COVID and begging for PPE and being told to go pound sand, right? Think about how meat packers and meat processing workers in 2024 work in conditions that resemble Upton Sinclair Chicago in 1904. Think about how every day people are working harder, longer, for lower pay and worse benefits, and they often have no place else to go. That is what labor monopsony looks like. And if we're going to stop what that does to workers, we need to be willing to stop the mergers that create it. And that's precisely what I hope we do. Thank you all so much. Thank you for having me. Unfortunately, I'm slipping out quickly, but I will be watching this afterwards. So thank you so much.
Thank you so much for those comments and for those powerful examples of that this is about the quality of people's lives, their safety, and workers' well-being. So thank you so much for joining us. And so now we're going to have our first panel. So if our first panelists could come up, we'll have a conversation, and then we'll have a few minutes at the end for questions and answers.
Great. Well, I'm delighted to be here. Actually, maybe I'll take my name is Kate Andreas, and I'm a professor at Columbia Law School and also co-director of the Labor Lab at Columbia. And we're delighted to be here and to co-host this event. I wanted first to briefly introduce our wonderful panelists, and then each of them will say a few words, and then we'll turn to conversation among the panelists and questions from all of you. So we have with us today Sandeep Vaheesan, who's the legal director at the Open Markets Institute. He leads Open Markets legal advocacy and research work, including its amicus program. He is the author of a forthcoming book entitled Democracy and Power, A History of Electrification in the United States, which will be published in December. Next, we'll hear from Laura Padine, who is the director of work structures at the National Employment Law Project. She focuses on improving working conditions and economic security for workers in fissured workplaces, including workers classified and misclassified as independent contractors and workers hired through labor intermediaries like temp staffing agencies. David Seligman is an attorney and the executive director of Towards Justice, a nonprofit legal organization that helps workers and worker organizations to take on abuses of corporate power through litigation and policy advocacy. He has litigated several cases on behalf of workers under the antitrust and consumer protection laws to attack employer misconduct that seeks to sidestep employment law protections. And before coming Towards Justice, David worked as a staff attorney at the National Consumer Law Center. And then finally, we'll get to hear from Terry. As you already heard, she's the director of the newly created NYU Wagner Labor Initiative here at NYU. Previously, she directed the state and local enforcement project at the Harvard Center for Labor and a Just Economy and was a senior fellow at the Economic Policy Institute. And before that, as Terry mentioned, she enforced labor laws for over 17 years in New York, including as labor bureau chief in the New York State Attorney General Office. Thank you. All right, so let's start with Sandeep. So that was.
Thanks so much, Kate. Thanks to Terry and Jonathan for inviting me and the NYU Wagner Labor Initiative for organizing this great event. It's truly an honor to be here. So for 40 plus years, our antitrust policymakers and judges have said corporate bigness doesn't matter. Bigness can actually be desirable. It can be a source of economies of scale and other productive efficiencies. Don't worry about bigness. I'm going to argue today that it's important to avoid the opposite temptation to say that corporate bigness is all that matters. An antitrust program focused just on addressing bigness will actually, in my view, not do that much to advance worker power and worker justice in the United States. And by bigness, I'm really referring to two different things. So there's one concept of corporate bigness, which is relative size, which is captured in market share and concentration, and then also absolute size, typically captured in assets and revenues. And without question, monopoly and oligopoly power consolidate power in the hands of few executives and financiers, which gives them great power over consumers, workers, suppliers, rivals, and really all of us as members of an at least aspirationally democratic society. And buyer power matters. Walmart squeezes its suppliers. They in turn squeeze their workers to maintain margins and stay afloat. Nathan Wilmers wrote a great paper in 2018 where he found that rising buyer power could explain around 10% of wage stagnation among non-financial firms since the 1970s. So not only is Walmart bad for its own workers, it's bad for all workers in its supply chains. And there's similarly been a second thread of research that's found many labor markets in the United States are highly concentrated. Workers have few prospective employers. That translates to a significant reduction in wages. All this said, antitrust enforcers and advocates need to think about more than just firm size. We also need to be talking about business practices and business models. Importantly, more than 100 years ago, Congress created an agency to do just that. It created the Federal Trade Commission to identify and stop unfair methods of competition, as Commissioner Bedoya explained. And this FTC, to its great credit, is actually taking up the mantle of policing practices and business models. Last month, the FTC banned non-compete clauses for nearly everyone. All workers are protected. FTC doesn't have quite complete jurisdiction over the economy, but it covers most of the economy. So putting that aside, workers are protected regardless of whether they are making $1 million a year, or wage, whether they're independent contractors or employees, whether they work for a large firm or a very small firm. The FTC correctly recognized that employer power is the default for everyone except a small category of workers, senior executives. This is a really good start, but there's a lot more for the FTC to do. Misclassification of working people is an epidemic today. Famously, or infamously, Uber, Lyft, and many others say their workers are independent contractors and not entitled to the rights of employees, including minimum wages, overtime, workers' compensation, unemployment insurance, and of course, the right to organize. So part of the solution here is fixing labor and employment law and then truly enforcing it. The National Labor Relations Board and Department of Labor are doing it. NLRB did it in the Atlanta Opera case, also did it in the joint employer rule. Obviously, the rule is not in that great place at the moment, but the NLRB and DOL are absolutely doing the right thing. But antitrust law must be a part of the solution too. Firms use contracts to recreate employment relationships shorn of the duties and responsibilities that come with being employers. Antitrust law uses a term called vertical restraints. I usually don't like antitrust jargon. I think it often serves to conceal great evil being done, but I think vertical restraints are actually quite a good term. Like, they capture the idea that there is hierarchical control being exercised. And antitrust law used to restrict vertical restraints, but since the late 1970s, the Supreme Court has empowered businesses to recreate business models where firms have control that comes with employment without the responsibilities. And this isn't really new. Like, Uber is often touted as being something novel and unprecedented, but businesses have been trying to do this really since the New Deal, and especially since the passage of the Taft-Hartley Act in 1947. I'll just offer a quick quote. This is from a 1963 case, just to give you a sense of how old this is. A lawyer for an independent gas station owner in California told the Supreme Court, "Now I submit that what Union Oil here is trying to do is get the best of all possible worlds. It is trying to have independent businessmen control their prices as though they were their employees, and yet it is not willing to treat them as employees and respond to state legislation with respect to workers' compensation, unemployment insurance, Social Security, and of course the federal NLRB statutes." So this is not new. The FTC can and should crack down on vertical restraints, both restraints as to pricing decisions as well as non-pricing decisions. If a firm insists on classifying its workers and trading partners as independent contractors, they should have the right to exercise effective independence. And while I'm up here, I'll plug my colleague Brian Kalachi's forthcoming book about this history, where he talks about how antitrust law has been instrumental to the rise and really proliferation of these business models. So I'll wrap by saying, the DOL and NLRB have initiated this process and done important work. Now the question is, will the FTC follow? And what we should hope for is some type of pincer movement where the labor agencies are tightening up standards around employment, and then the FTC is tightening up rules around vertical restraints using its antitrust authority, really forcing businesses to choose. If you want to exercise control, that's fine, but you have to assume the duties and responsibilities of being employers. If you want to treat your trading partners as independent contractors, respect the right to exercise effective independence. And I will say, if the FTC is looking for guidance, there's no better place to start than the work being done by David and his colleagues at Toward Justice. They're really at the cutting edge of this fight. So going forward, we need to focus on more than just corporate size. Corporate size, in a sense, freed us from the strictures of consumer welfare, but now it's important that we not be imprisoned by the idea that size alone is what matters in today's economy. Thank you.
Hi, everyone. It's great to be here today. And thank you to Terry from NYU Wagner for hosting us. As Kate mentioned, my name is Laura Gadeen. I am the Director of Work Structures at NELP. And I focus on ways employers structure work, whether that's misclassifying employees as independent contractors or hiring workers through intermediaries like temp staffing agencies that allow employers to degrade working conditions by passing a lot of the risks and costs of their businesses onto these subcontracted workers while increasing profits for investors and CEOs. These work structures also create barriers to joining a union, and they exacerbate occupational segregation because workers of color and immigrant workers are much more likely to be hired into these bad subcontract jobs. So what does this all have to do with antitrust law? Well, as FTC Commissioner Bedoya said, we see how these low-road structures, like misclassifying workers as independent contractors or hiring workers through the labor intermediaries who are just competing with each other on one thing, labor costs, these structures make it more difficult for employers who are doing the right thing to compete. And by right thing, it's, hiring workers as employees, not interfering with their right to join a union, for example. And we also see antitrust law as a way to highlight the contradictions in a lot of these work structures. Most prominently now, I think, the gig economy is getting a lot of attention, even though, as Sandeep mentioned, these structures have been around for a long time. So for instance, we have these digital labor platforms like Uber and Lyft and DoorDash, who we believe who say their workers are independent contractors, all running their own separate independent businesses. And yet these digital labor platforms are determining and controlling the key conditions of the work, including what assignments these workers are offered and what they're paid. If these workers were truly independent businesses, shouldn't this be price fixing and implicate antitrust law? It seems like these gig companies and other businesses misclassifying their workers want to have it both ways. They want control without responsibility. They want control over the workers doing the work that is central to their businesses without being responsible to these workers for complying with wage and hour laws, health and safety laws, and paying into social insurance funds. If the platforms want to call their workers independent contractors, then antitrust law should require these workers to be truly independent. Thanks.
Hi, everybody. Thanks so much to NYU, to Terry, and to everyone else who put so much work into organizing today's event. My name is David Seligman from Towards Justice. I have to say, I think I owe Sandeep one. That was that's a tough thing to follow up on. I appreciate everything Sandeep said about Towards Justice. I will say, everyone, we think of our work very much as following through on the frameworks that the people on this panel are helping to articulate and helping to use to change the discourse. A common theme of the remarks so far, which is what I'm going to dig in further on, is a business model of control without responsibility, control without accountability, right? How do corporations now exercise control outside of the firm, right? Outside of the firm in the traditional context, in order to evade legal requirements, state, federal, local labor standards laws, but also to evade the countervailing power of worker collective action, of unions, right? That is like fundamentally what we're up against, and I would suggest to you that this is one of the most important challenges facing us today. My 9-year-old daughter, I said to her once, she was talking about my work, and I said, I think one of the most important things that we could be doing in the world today is unionizing Uber and unionizing Amazon, right? And she was like, what about climate change, right? And my wife looked at me like, well, how are you gonna answer this one? And I was like, same thing, right? That's it, It's all part of the same, the same challenge. So I want to talk a little bit about how Towards Justice has has tried to use the antitrust laws to get at this problem, in particular through litigation and state and local advocacy and legislative efforts, right, which I think are really an important piece of the important levers in the sort of antitrust reform agenda. So, you know, the first case that came in our doors where we saw firsthand, where I saw firsthand, this is a business model that has been going on forever, but firsthand in a really stark way, how firms attempt to exercise control without responsibility happened when Andy Puzder was nominated. I don't know if people remember Andy Puzder, but Andy Puzder was nominated to be the Secretary of Labor, and he said something that I still just think is like jaw-dropping. I mean, he said lots of things that are jaw-dropping, but said something that was quite jaw-dropping for someone who's nominated to be the Secretary of Labor. He says, we don't even need minimum wage laws. All we need is a free market, right? I don't even know what that means. I understand less about what that means now than I did then in 2006, 2017. We looked at Carl's Jr.'s franchise agreements, and they had a no-push provision. So what that meant was that if you were an assistant manager or manager at Carl's Jr., you dedicated your life to in your professional life to the Carl's Jr. way, which is what they called it. You couldn't leverage the expertise that you had gained, you know, within this brand to try to go work for a different franchisor. Interestingly, the complaints we heard from workers wasn't only how that undermined wages. It was actually how it undermined their ability to seek out work where they would have more flexible schedules, right? Which is something I think we should all keep in mind when we think about, you know, the harms of these kinds of things. It's that we can't always put this in sort of simple wage terms. Wages mean lots of things to workers. We filed suit against Carl's Jr. under the California antitrust laws. The argument being, you can choose to control where what restaurants your workers are employed at. But if you do that, you've got to be responsible then. You have to be your employer, right? You can't, on the one hand, deny your status as an employer, right? And deny that you're part of a single firm. And, you know, on the other, and say that you're not responsible to these workers because they're employed by franchisees. Well, you know, on the other hand, restraining their ability to leverage their power through the threat of exit, the threat of going to work somewhere else. We've continued to see the problem emerge and have you know, one area where I think it comes up a lot, as Laura mentioned, is the app-based gig companies, right? Where I think gig workers understand this very well, right? They experience, you know, they're told they don't have a boss. They're told that they have independence. And very often what they see is that, and this is Commissioner Bedoya articulates this point in his misclassification speech, they see that they are operating within a veneer of independence and actually are subject to extraordinary control. We filed suit on behalf of several of Amazon and apologies, there was a slip up, but Uber and Lyft drivers in California, asserting that the companies can't, on the one hand, post Prop 22 in California, can't deny their responsibility to these workers under the labor laws, can't deny that they're an employer, and still fix prices. You know, importantly, we filed suit under California law. This gets at points in because some state laws, including California's, are more favorable to arguments that these types of vertical restraints are illegal and per se illegal, and don't need to be attacked under what we call in antitrust terms the rule of reason, which has become quite a hard standard to enforce the laws under. I think it's exceptionally important, right, that the antitrust laws provide us with the framework, but at state, federal, or local level, the antitrust laws provide us with the framework for attacking vertical restraints as vertical restraints. I think it's exceptionally important that we do so. We see very often that horizontal arrangements, especially when used to punch up, right? Especially when used to, for example, to as in the context of Uber and Lyft drivers organizing, for example, that that kind of coordination is not only beneficial but essential to a fair marketplace. But vertical controls, are deeply problematic. The antitrust laws provide us with the tools to get at those problems. The antitrust laws aren't just about collusion, but also about coercion. I'll finish by highlighting a business model that we find exceptionally troubling, and I think is a useful thought experiment for these issues, which is Amazon. Amazon several years ago, confronting the problem of their lack of control, complete control over their last mile delivery, massively expanded what we call the DSP program. The DSP program involves the employment of hundreds of thousands of Amazon delivery drivers who drive those gray vans with a smile on them through corporate middlemen, through DSPs that Amazon contracts with. That almost always these companies work exclusively for Amazon and are subject to all kinds of extraordinary controls by Amazon. But Amazon says that the hundreds of thousands of drivers that they control are through these companies are not Amazon's employees. That's again an extraordinary amount of control without accountability. If you contrast the business model with what we see, for example, at UPS, right, where we see drivers around the country doing work directly for a company and working under a CBA, right, within a union. And I think that the contrast between the business models is really helpful and highlights an area where the importance of the antitrust law is to go after vertical strengths. So, anyways, turn on the story.
I get to bad cleanup for the initial statements, and I'm just going to talk about three things in particular. One is just to reemphasize how broken the labor and employment law system is, which I think David and Laura will talk about a little more, and Josh already spoke about at some point to some extent. I'll talk about how unfair competition has actually already been used as a basis for pursuing workers' rights cases. And also talk about the fact that unfair competition, it's based on misclassification, for example, is real. So in terms of how bad it is and how broken the labor and employment law system is, I'll just share a few items that sort of follow up on some of what Josh said. First of all, private sector union density. Does anyone know what the private sector union density rate is right now? Yeah, 6-7%, something like that, which is around what it was at the time that the New Deal was passed and at the time that the National Labor Relations Act was passed. So it's extremely low, and that's down from around a third of workers in the post-war period. And this is relevant to creating more degraded working conditions in so many ways. First of all, unions raise standards for their own members, but also for non-unionized workers when unions have sufficient density in an industry, because the non-unionized employers have to raise standards in order to compete. Unions also play a really important role in allowing workers, for example, to report violations without fear of retaliation. They create an on-site monitor within a workplace to make sure that laws are being followed. They're also active politically, which means that they help to fight for stronger labor standards and fight for more enforcement resources. And they also have an impact on democracy. There's studies showing increased civic participation, voter registration, and voter participation, and also elected officials and candidates who come from working class backgrounds where you have higher union density. So there's like that 6% number. It really is a huge problem that plays a big part in the disparity between corporate and worker power. That 6% number stems from many factors, and people have written probably some of you here have written books about it. But our labor laws, our federal labor law is really broken. Everybody kind of knows that. There are still workers who are incredibly courageous and powerful, and like people who are incredibly strategic, who manage to win, as UAW has done and hopefully will again this month. But there are a lot of obstacles. Employers routinely retaliate against workers and violate their rights when in the course of union campaigns. And for example, once a union wins an election, the employer only has a duty to negotiate in good faith, but that can sort of, that they can drag out the process a long time. And all of this that I'm saying, the reason that I'm like doing this parade of horribles, and I generally like to be a little more positive than this, is just because people who come from an antitrust background, it's really helpful to understand just how bad it is. And then the third thing that I'll mention is just the scarcity of enforcement resources in the labor and employment space. The Department of Labor's Wage and Hour Division enforces the minimum wage laws, overtime laws, prevailing wage laws, the Family and Medical Leave Act, and the child labor laws. Who wants to guess how many people they have nationally? Anyone? At the end of 2023, it was, I think, 833 people for the entire country, which is around 500 fewer than in the late 70s when the economy was much smaller. So we have really grossly insufficient enforcement resources. And so you sort of put all of this together, that unions have always played a role in on-site monitoring and raising standards. The law needs to be reformed, the labor law. Our other employment laws are not adequately enforced. You add forced arbitration to all of this, and private lawyers who used to play an important role in vindicating workers' rights are now really stymied in their ability to bring cases to court, and many cases are not brought. So you really have these and several other factors that create a situation where there's like really, really degraded working conditions, as well as a vast disparity of worker and employer power. So that's the first thing I want to say. For the antitrust people out there who are not steeped in labor issues, it's really bad. The second point that I want to make is, interestingly, unfair competition has been used as a basis for wage and hour enforcement. I work a lot with state attorney general offices, and I worked at the New York AG's office for many years. AGs have really varying powers and jurisdiction and authority. And so, they're always trying to figure out like, what's the jurisdictional hook? The California AG's office routinely, what they use for jurisdiction for their wage and hour enforcement and other worker protection cases is unfair competition law. They routinely bring minimum wage, misclassification, and other worker-related cases under the state's unfair competition statute, and they have done this for years. They did this like 10 or 15 years ago in relation to cases where there was misclassification with port truck drivers. They used unfair competition in the Uber and Lyft to sue Uber and Lyft for misclassification. They used unfair competition as the statutory hook that gives them jurisdiction in relation to a case where Amazon wasn't notifying workers about COVID cases in their facilities. And they also used unfair competition in relation to a construction contractor that didn't pay unemployment insurance and overtime, and on and on and on. If you look at their complaints, their lawsuits, they all cite unfair competition. It's in all of it's like utterly routine and basically all the complaints that I could find where they were vindicating workers' rights. So that's my second point, that this is already being used by the California AG's office, and more offices could use this more enforcers could use this as a means of getting jurisdiction. And then my final point is that, like, to me, when I heard about this, I always thought, ooh, that's a clever way of getting jurisdiction, but it just seemed like a clever lawyer trick. And I didn't really fully understand or grasp just how actually appropriate it is until felt relatively recently. I wrote a guest essay in the New York Times about these gig companies that are in the hospitality industry and healthcare that are, now using the gig model. And after I published it, I heard from a couple of employers who run temp agencies that actually hire people as W-2s, treat them as employees, pay unemployment, pay workers' comp, et cetera. And they said, I cannot compete with these people who are these new entrants to the market who are violating all of these laws. And one of them said, we left a particular major metro market altogether because we were losing all of our business because we were charging more to clients because we were following the law. And so, it should go without saying, but you should not have to cheat in order to compete. So the savings, just to give people a sense of it, the savings are really considerable when workers are misclassified. The general estimate is that it's about 33% roughly, or could be more, that employers save by not paying unemployment taxes, workers' comp, the employer's portion of FICA, overtime, not having to provide PPE, paid sick leave, all of these things. So it is really, really an unfair method of competition. So, so that's what I'll offer for my opening remarks. And I'm really excited for our conversation.
Thank you all. So I'll start off with a question and then we'll open up for audience questions as well. So Terry really highlighted the problems with labor law, which raises the question, I think, that why not attack these issues facing workers through labor law reform? Why address these problems as problems of antitrust? Is the answer to that just that achieving labor law reform is impossible, or are there sort of first order reasons why antitrust is the place to be focusing, or at least another place to be focusing? Anybody?
Yeah, I'm happy to take that on. I think there are a couple of really important benefits to bringing antitrust law and competition law into the mix here. The first, it allows us sometimes through creating this sort of pincer move that Sandeep highlighted. It allows us to attack business models at a really structural level, right? And to force corporations to make choices, right, about how they structure themselves, right? It forces them, especially like alongside labor law enforcement. It could force them to, either not exert the control that they are exerting over their workers and over the people who drive their profits, which I think in many contexts is not actually possible for their business models, or to acknowledge their accountability and responsibility to those workers under the labor laws, right? And their accountability to the countervailing power of workers. I'll also highlight, and this is something that we've seen in a lot of our litigation, I think that alongside labor law enforcement, the antitrust laws offer a really powerful tool for organizing. Very often, the frameworks of antitrust, especially when you strip away the jargon, is something that workers find really compelling. Our clients in California, for example, understand very well that they are subject to a scheme of control without responsibility. They feel like they are the victims of a vertical price fixing scheme, and giving them the frameworks to make that argument has been a powerful organizing device. That's something we also see in the Fisher workplace context. We worked with 32BJ, for example, on a complaint before the FTC involving a case where a staffing agency had an agreement with its clients. The staffing agency for building services workers had an agreement with its clients where the clients, the buildings in many in the New York City area, were effectively prohibited from hiring on the staffing agency workers for permanent employment and for direct employment. That felt to them not only like a way for the staffing agency to exert its power and undermine their bargaining power, but it felt to them like an antitrust violation. We think it is one. I'll say though that even when you do bring, even when the antitrust claims or the antitrust laws aren't on the table, I think that there are really important ways in which the vocabulary of antitrust can help to inform labor law enforcement. And that's something that we've seen that I think has been really powerful. So for example, we have been bringing cases across the country involving what we call stay or pay contracts that prevent workers from leaving a job unless they pay their employer sometimes tens of thousands of dollars before the end of their the end of their term of employment. In these cases, workers experience that as a really aggressive non-compete or indentured servitude. They experience it in antitrust terms. And we have found even when we don't bring antitrust or unfair competition type claims, that we can articulate that same understanding of the injustice through the wage and hour laws, right? Because these are also the way that these stay or pay contracts work is they work as a threatened kickback against wages. So, what the employer is effectively saying is if you leave your job, you have to pay me back the wages I've already paid you. That's a minimum wage violation, right? But in the ways we talk about that case, in our complaints, and in the ways that workers talk about that case to each other and to the media, we can talk about that as a restraint on worker mobility. I'll say this is something that we have seen our federal labor standards enforcement agencies do a lot more of, which I think is like terrific, right? So the Department of Labor is doing a lot more work in this space and expressly interested in wage violations that impede worker mobility. The National Labor Relations Board, right, has articulated how impediments to worker mobility can be used to undermine workers' Section 7 rights. And so I think that it's not just about the laws themselves and how antitrust laws can be brought to bear on these problems, but how an affirmative and positive vision of antitrust can help to inform the way we enforce other sets of laws.
I think also, I think we need a lot of tools and a lot of levers at our disposal to really kind of go after corporate dominance, particularly right now where our labor laws are both weak and under enforced. So, I think antitrust law can really take a more holistic approach to corporate dominance and the ways it creates and reinforces an imbalance of power between workers and employers. So, kind of one example is monopolies and duopolies, and particularly Uber and Lyft are a really good example of this duopoly. And we've seen how they have created this duopoly around our country, and they've used it to threaten to pull out of markets when workers get organized to pass labor standards. So they did this in New York City and Seattle, which I think are the only two jurisdictions that have passed wage standards for the drivers, and they didn't pull out. And now they're doing the same thing in Minneapolis. Minneapolis drivers organized and were able to successfully pass essentially a minimum wage rate for ride-hail drivers in Minneapolis. And right afterwards, Uber and Lyft threatened to leave. And it's kind of amazing for two companies that have like no capital investments in the state, right? And, you're saying it's just an app, right? Like, can anyone else do this? And it's really amazing because we have seen the mayor in Minneapolis be concerned about it, and now the state. And, it's really unfortunate that these two companies can really just kind of subvert government and local democracy. And so it's, in a truly, and then, it's also the fact that they threatened to pull out of Minneapolis, like almost at the same time. Like you would think, if your competitor left a market or threatened to leave, you'd be really happy about it, right? So that is also, deeply, deeply troubling. And it's also just the layers of it are, they have embedded themselves in local government by getting contracts to provide transportation services to people with disabilities. And so we really need kind of our local communities and our government to think more innovatively about this problem, both the root causes in terms of disinvestment in what should be public services like transportation, but also really encouraging true competition in local markets. And I'll just say one other thing related to this that I think implicates both labor law and antitrust law is that we have more and more companies that are collecting enormous amounts of data about us as consumers and as workers. Obviously, the digital labor platforms do, but so many other corporations are using technology this way, and they're collecting that data and using it in ways we don't know, but very likely to set individualized prices, to set individualized wages based on information they're collecting about us. Uber's CEO recently started to insinuated that that's what they're doing. And so I think, antitrust law could really be used to look at this as an unfair method of competition and demand more transparency about what's happening here.
Oh,
Oh, go ahead, Sandra.
yeah, so I view antitrust law and on the one hand, and labor and employment law on the other hand is complementary and mutually reinforcing. Terry talked about how, obviously, one class of victims are the workers who are shortchanged on wages, prevented from organizing, but a second class of victims are the honest high road competitors. And they are placed at a permanent disadvantage when firms are allowed to break labor and employment law with impunity. And that contributes to an erosion in labor market standards over time. So this is very much in the wheelhouse of, I would argue, the Sherman Act, but certainly the FTC Act. And when Congress passed the Fair Labor Standards Act in 1938, in the purpose and findings section, it said that paying workers a sub-living wage and overworking them constitutes an unfair method of competition. So Congress very much thought of these fields as adjacent and deeply intertwined. And actually, Donald Richburg, who authored many important New Deal laws, originally proposed that federal wage and hour law be established through an amendment to the FTC Act. So in a sense, what we're doing is we're bringing two areas of law, two communities that haven't talked much at all for 70 years back in communication again.
I would just add also that I think about these issues as an enforcer, and as an enforcer, the answer is always, why not both? Like, why wouldn't you plead as many, causes of action as you can? And I would also note that when we think about the employers that are the most exploitative, they're not like, well, should we underpay workers or should we have a no coach? They say, why not both, right? And so we really need to have all of the tools. Again, it just goes back to that like vast power disparity and government being able to use all the tools at its disposal on the side of working people to create better lives.
So let me put one more question out there before we open up, which is I'd be interested to hear you highlight what you think the most important achievements have been thus far of the Biden administration and what you think, what changes in the law need to be at the top of the agenda next, either at the federal level or the state level.
Yes, start. So I'll talk about antitrust. Laura, David, and Terry are much more informed about labor and employment law side than I am. So the antitrust side, I think the single biggest achievement so far has been the non-compete rule that the FTC issued 2 weeks ago. It's a blanket ban, which I'm still kind of amazed to see happen. I figured, given the industry pressure, given what the scholars were saying, I figured, they would do something more targeted. Still good, but not quite a universal ban, but they did that. I think this has to be a first step toward challenging broader set of vertical restraints. I worry, even if Biden gets a second term, I worry that the FTC might say, okay, we did the non-compete rule. Please give us a pause, please credit us. But that's the extent of our work on vertical restraints. And if that's the case, obviously the rule is great. I hope it survives all these court challenges, but it'll be a huge missed opportunity. This needs to be the initiation of a sea change around vertical restraints in general. Second, and this is where the FTC is, I think, come up short. They need to do what David has said. They really need to unsettle this horizontal vertical distinction and tell businesses, tell the public, vertical restraints are not going to be tolerated going forward. And at the same time, we're going to give a lot more space for workers, professionals, and even some small businesses to engage in horizontal coordination against more powerful actors. And the individual commissioners, specifically Bedoya and Slaughter, have said some positive things in that spirit, but there's a lot more work to be done. The FTC needs to be putting out policy statements saying, we will not investigate or prosecute certain types of coordinated activity among powerless actors. And then they also need to get involved in the courts, tell the courts, the labor exemption is drafted by Congress, enacted in the Clayton and Norris-LaGuardia Acts, makes no distinction between employees and independent contractors. The word independent contractor is not found in the statutes. Please live up to your professed textualist principles and faithfully follow the statutes enacted 100 years ago. So non-compete rule is great, but it's just the first step.
I definitely agree with Sandeep that the non-compete rule is is amazing. And I applaud the commission for not creating exemptions based on wages, how much someone makes on that. I think one thing on the non-compete rule, and then I'll say something on the DOL independent contractor rule, which I also think is quite strong. I think it didn't get a lot of attention, but the non-compete, a lot of so-called independent contractors are bound by non-compete clauses, which just shows what a sham they are. That you're supposedly your own business, but you can't work for more than one entity. Daniel Papskin at Capital Forum showed me a contract a few weeks ago about insurance agents. In their contract, they can only sell insurance products for one insurance company. And they are banned from selling products or working in any other way for a competitor, and they're so-called independent contractors. And that, along with, many other parts of the contract that very much limited, controlled how they did the work, the number of meetings they had to do, the number of sales pitches they had to do. I mean, these are sales agents that should be employees of the company, but they're not. So, the non-compete rule would bans non-competes for independent contractors as well. And then secondly, I'll just say the DOL independent contractor rule was recently finalized a few months ago. It's a very, very common sense rule that focuses on who's an employee under the Fair Labor Standards Act, which that's the federal minimum wage and overtime protections, and who is an independent contractor and therefore not covered. And so again, this is enforcing the Fair Labor Standards Act, which is our federal minimum wage and overtime. The rule doesn't have any applicability unless there's an FLSA violation. It's amazing how many people from high wage sectors, like the financial services sector, have been lobbying against this rule that really should have no applicability to them. But that's neither here nor there. The great thing about this rule is that it's a balancing test that really gets at the kind of central question here. Are you in business for yourself, or do you find work in the business of others? If you find work in the business of others, you should be covered by our federal minimum wage and overtime law. And the rule also just gets into the ways, technology increasingly is being used to set, determine, control people's working conditions. And that absolutely, even though those kind of levers of control are also often made invisible through the technology, that they are a central part of this test. Again, that of course that's rules being challenged 20 different ways, but hopefully it will be, it will stand.
Yeah. Non-compete rule is amazing, and I do want to say really appreciate Sandeep's leadership on the advocacy on that rule. And for OMI, in terms of areas for growth, and there's a lot of them, I do want to just identify one and highlight it in particular. We are living in an enforcement crisis, right, in this country. You've heard that. I think that's been a persistent theme throughout the day which is there are rampant violations of law and outrageous under enforcement. And I think that should very much be the focus of a lot of what we do at federal level, at the state and local level. That includes making it easier to enforce these laws. So getting at the sort of the outrageous sort of costs and judicially imposed unnecessary complexities to, for example, the rule of reason, which makes it impossible to enforce very difficult sometimes to enforce our antitrust laws in the vertical restraint space. It also should mean that, when we talk about anti-monopoly, when we talk about labor standards violations, in the same sentence, we should be talking about the outrageous harms of forced arbitration, right? Because, we sued Amazon in Federal District Court in Colorado alleging that the company, while exerting these outrageous controls over drivers, thousands of drivers across Colorado are having to pee in bottles, defecate in bags in order to stay on task with the quotas set by Amazon, and yet Amazon refuses to be their employer. It refuses to acknowledge its employment status. Amazon, meanwhile, seemingly requires its DSPs to enter into identical forced arbitration agreements with drivers. When we file suit in federal district court in Colorado, we say, you're on the hook, Amazon. Amazon says, nope, we're going to try to enforce contracts to which we aren't even a party, the contracts between DSPs and drivers. We think we should win in that fight, but under federal law, they get to make the argument and they get to delay the case for years. It goes up on appeal. All the while, people around Colorado will continue to have to pee in bottles in order to stay on task for Amazon.
So I'm going to answer that. Anyone who knows me knows how I'm going to answer this question, which is I'm going to answer that I want to talk about the role of states and local government in this area and the incredible importance of what states have done, and not just focus solely on the federal government. States have really played a big role in relation, for example, to enforcement. State AGs have brought big cases in relation to no poach agreements. The New York AGs brought a lot in the title insurance area. The Washington State Attorney General did an entire no poach initiative with hundreds of franchisors nationwide and got all of them to stop using no poach agreements, not just in Washington State, but nationwide. And in fact, I think some people here did a study of that and found that there was actually an increase in workers' wages resulting from that enforcement action. The New York AG's office, it started when I was the labor bureau chief. We did some cases involving non-competes, using whatever jurisdiction we could cook up, although it was fully valid. And we also the Illinois AG's office has brought cases involving non-competes. Now that DC has a new law, the AG's office has brought cases and is looking at non-competes. The recent lawsuit by the FTC challenging the merger of Albertsons and Kroger, that was not a solo effort by the FTC. There were a number of state AGs and states that were also a part of that lawsuit. And for example, the Illinois AG's office recently brought a lawsuit against 3 staffing agencies and their mutual client, alleging that they had unlawful agreements to refuse to solicit or hire each other's employees and to fix employees' wages. In January, the state Supreme Court issued a ruling agreeing with Kwame Raoul, the state AG, that the Illinois Antitrust Act does not exempt Illinois labor markets from antitrust scrutiny. So we see that there are state enforcers really playing a role in this. And I think that it's, as we think about the uncertainty of what's going to happen in November, I think it really highlights the critical role that states can play, and that, as the federal government gets, more or less favorable, depending on administrations, that having a strong footprint of state enforcers in this area is something that is really, really critical. And also, we all know that the federal judiciary, and we know the composition of the Supreme Court, state courts may themselves be more favorable. States can develop their own case law. AGs also can bring cases charging in the alternative, which the federal government, often the agencies are limited to their own statutes, whereas an AG can bring a case that's under, the antitrust law, and in the alternative, employment or labor laws or consumer or investor protection. So that's very powerful. And then one last thing that I would say, a couple of things. I think AGs often are very mission driven, and some of them don't have that much risk tolerance, but some of them have a lot of risk tolerance and are willing to do cutting edge cases to really stand up for people. And states have a history of collaborating in multi-states. And I think also legislation at the state level is really, really important because it can provide proof of concept that then allows it, in the laboratories of experimentation model, allows it to be adopted at the federal level. And we saw that with non-competes, that we had a lot of natural experiments occurring because of states passing different laws related to non-competes, curbing non-competes. And then that provided an ability for researchers to study those natural experiments and conclude and submit to the FTC, hey, these are the actual, not just theoretical, but the real world results of curbing non-competes. And this is how it affects the economy. And so I think that's another really important role that states can play. So I guess my answer is not fully responsive to the question, but I do think it's important to note the critical role that states can play both during times of the federal government, they're a hedge when the federal government is not favorable to workers, and they can be really cutting edge even in a time when the federal government is more favorable.
The question was at the federal or state level, so perfect answer.
Okay. Oh, it's responsive.
So we have time for a couple of questions. I think I'll group a couple and then have the panelists respond if there are any from the audience. Great, yeah.
I've been working with the Carpenters Union a fair bit on the issue of misclassification and unfair methods of competition. One thing that we've seen as we look across the state laws, oftentimes these unfair methods of competition laws are balled up in consumer protection statutes. And from my question to you all is, do you have any great ideas about how to treat workers as consumers of employment opportunities?
Question. Let's get a couple more just so we can.
I'd be curious to hear what particularly in red states are gonna do to basically either neuter stuff that's happening at the federal level, or if these same tools are sort of passed, how they could be abused by Republican administrations, and just sort of give us a lay of, let's imagine a whole different balance of political forces are in power, what goes wrong?
Then one more and then we'll get responses and then I think we're out of time.
Okay, so the FTC has an unfair methods of competition authority that it used to ban the non-compete. There have been statements by Commissioner Bedoya about applying it in misclassification and potentially vertical restraints contexts. But the FTC's UMC, or unfair methods of competition policy statement, was very broad in identifying coercion and exploitation as unfair methods of competition. So I'm wondering what your dream list of UMC in the context of labor markets might be, including captive audience meetings and other forms of employer coercion that could be targeted by the FTC.
So.
You have 2 minutes, so good luck.
Okay, well.
We could go all day.
Anyone want to tackle any of this?
I wanted to follow up on your question very briefly. We've seen this in a lot of state statutes as well. Many state, even sometimes in their consumer fraud statute, they'll say unfair and deceptive acts and practices and unfair methods of competition are prohibited. That's a mini FTC Act, right? That's what the FTC Act says as well. Under many states' laws, whether workers are covered is frankly not that complicated and difficult of a question. They just are, right? And there's lots of precedent across the country that they could be. Many of that precedent arises in the unfair and deceptive acts and practices context and not in the unfair method of competition context. But the same analysis should arise. I'll say that there is also some bad case law at the state level, like late 80s and early 90s. So lots of bad things happened in this space, right? But I see a lot of bad case law where courts will say, well, clearly this wasn't meant to cover labor. But that is, in our review, that's not the norm. And I think that that's something that we can and should be pushing back at the state level. I'll say state legislative, this is where state legislative work can be exceptionally important, and where I think we can gain a lot of ground.
So any last quick answer to either red state threats or UMC ideal?
I'll just say a bit of what Sandeep said in terms of using UMC to regulate vertical restraints more closely. We see this in a lot of different ways. And there's a lot of evidence, again, that subcontracting, particularly hiring workers through labor intermediaries, temp staffing agencies, in the wireless industry. We've done work with CWA, highlighting, for instance, when AT&T and other wireless contractors subcontract their retail to wireless authorized dealers, how that hurts working conditions, and they're still controlling the kind of workers' working conditions. So I think more work there would be great. I don't know if there's a way. I'm just going to put out my absolute best, and I don't think this has anything to do. I don't know if that arbitration clauses, which is what David was talking about. I think the fact that essentially we've allowed corporations to waive their right to be sued in court is an abomination and has made it impossible to challenge systemic practices, whether consumer practices, worker practices. So I don't know, can we all talk about a way to get the FTC to go after that?
Algorithmic control too. I mean, I think there's a lot that can and should be done when it comes to algorithmic control of workers, wage manipulation, privacy violations that come along with it, all those things. It's a whole nother panel, but we could keep going.
All right. Well, please join me in thanking the panel.
Thank you, Terry, and thank you, Terry, for doing all the work and organizing that you've done to get everyone here and get everyone registered so that everyone could get in. My name's Amanda Lewis. This panel is called Why Merger Review Matters for Working People. And it's, I think, particularly timely and also hopefully will resonate and maybe inspire people to get involved in merger review from the labor side, because it's really significant. It has, as we heard from Commissioner Bedoya, consolidation of employer power and monopsony power has a real impact on workers. And this is, I think the process can be a little bit opaque, but hopefully we're going to try to demystify that a little bit. And labor and workers really, you're entitled to a seat at the table. And so I think, to a certain degree, you really just need to show up. But we're also going to talk about some other changes. Certainly there are opportunities under current law, under current agency processes, but there could also be changes that would really make labor participation in merger review more easier and more impactful, and in a way that could be also more informed by more access to information about the mergers, the proposed transactions. So let me do, I know we're already running late, so I wanted to, I'll do introductions first. So actually before I do introductions, I did want to say one other thing, which is that for table setting, this panel is not a debate about what the goals or purpose of antitrust law should be. You could go to maybe like the ABA antitrust spring meeting for that, but that's not what this is. We are starting from the premise that antitrust law should, can and should be used to build worker power. And so we're gonna start from there, and we're gonna talk about how you can do that more effectively and how we can push for changes to allow for that to happen more effectively. Okay, now introductions. In no particular order, except for the order that I wrote down on the page. Start with Hal Singer here, all the way to the right. Hal is a professor of economics at the University of Utah. He's the director of the Utah Project and managing director at Econ One. I think I'm on the advisory board for the Utah Project and would definitely recommend that people check that out. Hal has secured 3 class certifications in labor antitrust cases alone, which is a pretty big deal. That was including in UFC, Arizona travel nurses, and just this week in chicken growers antitrust. So congratulations, Hal. Hiba Hafiz is an associate professor of law and McHale faculty research scholar at Boston College Law School. And Hiba recently served as an expert advisor to the FTC on labor competition issues. Prior to being a professor, she represented workers in antitrust class action cases at Cohen, Milstein, Sellers, and Toll. And particularly relevant to this audience, she got her start as a graduate student union organizer at Yale with Unite Here. Next, I guess I will go in order. Brian Kalachi, to my left here, is the chief economist at the Open Markets Institute. And I added, he didn't give this to me, but he is a prolific writer on the topic of labor and antitrust, among others. I don't know where you find the time to do it. You and Sandeep are just constantly coming out with really amazing and informative content. So I thank you for that. And finally, Suresh Naidu is the Jack Wang and Echo Run Professor of Economics at Columbia University. And Suresh co-directs the Columbia Labor Lab, which engages in research and data partnerships with unions and other labor organizations. All right, so let's get started. Al, as we just discussed, you were an expert witness for a recent antitrust case, and that was the one on behalf of UFC fighters. You recently had a great outcome for those workers. Can you talk about this case as an example of where merger review went wrong and really failed the workers that were impacted?
Sure. Can I steal your mic or someone else's mic?
Yes.
Thanks, Gail. And yeah, I am going to speak about UFC. It is settled, although, can you guys hear me? The settlement is not yet approved by the judge, so I'm skating on a little thin ice, but I'm going to keep everything to what's in the public domain already. The UFC case, I think, is a great template for both panels today. It's got non-compete elements, which I'll get into briefly, but also UFC, you may not know this, its dominance was solidified through a series of mergers. UFC actually purchased rival platforms, including the WFA, the WEC, Affiliation, Pride, and then finally the big one was Strikeforce acquisition in 2011. And at the time, Strikeforce was a serious alternative employment platform for professional MMA fighters. Of course, that acquisition was waved through by the FTC in 2011 without even the blink of an eye. Presumably, they were still stuck on looking for welfare effects or welfare harms on the consumer side of the market in terms of higher pay-per-view prices. We ended up getting that too, but they completely missed what the merger would do if UFC was able to take out its largest platform rival in terms of giving fighters an outside option to at least play off or bargain against the UFC for payment. I'll give you a factoid. This is in the public domain, so Hiba, take a breath. Hiba may have worked on that case too. Strikeforce at the time it got purchased was paying its fighters, and I'm not mispronouncing this, 60% of event revenues. Fighters were keeping 60% of the purse. Okay? At the time the UFC purchased Strikeforce, UFC was paying its fighters about half that. 29%. Oh. And after the acquisition, after the UFC was able to bring in all these fighters and put them under their exclusive long-term contracts, they were able to push down the wage share from 29%, this is in the public domain, to 19%. Okay, that's a 10 percentage point downward swing for the fighters. It just goes to show how important it was that this outside option, I mean, a lot of forces were working against the fighter, but taking away their primary outside option, employment option, was a really big deal. Now, we built an econometric model that tried to relate what we call the foreclosure share, the share of the fighters that were fighting at any point in time subject to an exclusive or exclusionary arrangement, and the wage share. And we were able to show that, sure enough, as the UFC grew, its foreclosure share was able to put downward pressure on wage share and wages. Very quickly, because the other panel is on non-competes, I just want you guys to know, there were two aspects of the fighter contracts that have the look and feel of non-competes. I'll go through them quickly, but you should know about it. The first was an exclusivity provision. This meant at the end of your contract, you had to wait 3 months, which doesn't sound like a lot, but just wait, before you could go out and kind of test the waters to go work for another platform, to go fight for another platform. After the end of that 3-month period, there was an additional 12-month period that got tacked on that also effectively bound you to the UFC. It was called the right to match provision. What the right to match provision said was that if you were foolish enough to go out and get an offer from a rival platform, all the UFC had to do was match it and your contract would automatically renew. Right? So you were effectively locked in for life. And the combination of the two created what was a 15-month cool down period. So if you wanted to leave the UFC, you basically had to go without eating for 15 months, which is hard for a lot of these.
Yeah, even 3 months is a long time.
3 months is a long time. Now, We, in addition to getting, the settlement gave the fighters $335 million. I don't get any of that. If I did, I would be buying cocktails tonight. But it also secured some significant injunctive relief, which is private right now, but it does relate to this 15-month waiting period. Finally, my last point, the first panel talked about the FTC's ban of non-competes by rulemaking. And I just want to commend this decision and say that, in particular, my experience of the UFC battle, which went on for 10 years, the complaint was filed in 2014. We didn't get relief until 2024. There were thousands of hours of billable time just to my staff who worked on it over the course of a decade. We wrote about 5 reports. I was deposed twice. We had an expert evidentiary hearing in Vegas where I was put up against 3 different expert economists in academia. And it got appealed to the Ninth Circuit. There were Daubert challenges. We got lucky. We basically dodged about 100 bullets to get the outcome that we did. And so to summarize, if you ever hear anybody on Twitter, I'm not going to mention any names, who tells you that, no, non-compete cases ought to be adjudicated on a case-by-case pursuant to the rule of reason, I would just ask him kindly, to talk to someone who's actually been through it before making such stupid pronouncements.
Yes, and that's not to mention all the lawyer hours and that wasn't even a case that went all the way through all of the appeals because it's settled. So if they didn't settle, that would still be in litigation and we would probably be years away from the fighters seeing any relief. So like over a decade, litigation is not efficient. It should be a last resort to dealing with these problems. So Hal, gave us this example where merger review really did fall short. And, I'd be interested to know, but probably the workers were never, the fighters didn't have a seat at the table and probably weren't involved in that merger review. Nobody at the FTC probably called them up and said, hey, how are you going to be affected by this merger? I do think, I know from experience that has changed. Staff attorneys at the FTC are very much encouraged now to pick up the phone, reach out to workers and labor. They don't always know the right people to talk to. It's not always obvious. So again, just like if you can, maybe it seems intimidating, but it really isn't that much. Just if you pick up the phone, you will get a response. I think I can say that as a former FTC attorney. So I think so that's actually a great segue to the fact that really under current antitrust law and agency processes, we want to talk a little bit about what are the most important tools and opportunities that labor can pick up and use, starting today to build worker power. And we're going to start with Hiba.
Yeah, okay, so bear with me. Some of this is going to be a bit technical, but we are dealing with the administrative state and there are procedures, but that there also means a lot of opportunities for worker involvement. So first thing I'd say is get involved in the merger process. The antitrust division of the Department of Justice and the FTC bring the vast majority of challenges to mergers. But private parties can also challenge mergers. So keep that in mind. There's a private right of action. And while merger policy before the 1980s was primarily made through judge-made law in the courts, since the 1980s, most merger policy until recently has been set through agency regulation instead, so bypassing the courts. And that's because the merger review process has been significantly streamlined to a relatively small set of mergers that meet certain thresholds, primarily tied to deal size. So very generally deals at over roughly $120 million that have to get reported to the agencies under a 1976 law, the Hart-Scott-Rodino Act or the HSR Act, which requires firms to report their deals for pre-approval. And there are two key agency tools that guide the merger review process that are important for workers and unions to dive into and know really well. And the first is the HSR reporting requirements as they're laid out in the agency's HSR form, which was recently rehauled and proposed last year. And then second are the merger guidelines. These are most recently issued at the end of last year, and they give regulated parties guidance on how the agencies will be reviewing mergers to assess their labor market effects. Okay, so first the HSR forms. The HSR forms are basically agency mandated disclosure forms that require firms seeking to merge to tell the agencies information that the agencies think will be relevant for analyzing whether a merger is going to raise red flags under the antitrust laws. So whether under the statute, quote, in any line of commerce or in any activity affecting commerce in any section of the country, the effect of the merger or acquisition may be substantially to lessen competition or tend to create a monopoly, including in labor markets. And the new HSR forms are really important because for the first time ever, the agencies are requiring merging parties to not only give them documents and information about product and service markets that might be affected by the mergers, but also documents and information about how labor markets will be affected. So under the new form, merging parties have to give the agencies information about their workers to screen for labor market impacts. And these include things like the firm's largest employee classifications based on the DOL Bureau of Labor Statistics SOC system that classifies workers into different occupational categories by the type or features of work that are performed and the location of work that occurs within the firm and the merging firms and the merging parties. So firms have to identify which classifications are impacted and how many employees they have in each. Geographic market information that lists commuting zones and total number of employees within each commuting zone, and information disclosing penalties or findings that were issued against the merging parties by the labor agencies. So by the Department of Labor's Wage and Hour Division, by the National Labor Relations Board, or by OSHA during the 5-year period before the filing. So the new form says that, quote, if a firm has a history of labor law violations, it may be indicative of a concentrated labor market where workers do not have the ability to easily find another job, end quote. So this is great. First, because it indicates that the agencies are willing to view unfair labor practices as indications of concerning market power or market power that could trigger the agency's review. Not just how much a merger might impact workers' outside options to switch employers. Right? So it could be based just on ULPs. And it's also great because these are things that workers and unions no longer have to work to provide at their own expense. Employers have the burden of disclosing these, and this serves as a new deterrent to labor law violations to the extent that employers want to protect their deal making. And the second, we have a new set of merger guidelines that for the first time explicitly describe the analytical process that the agencies will deploy when they're analyzing the labor market effects of mergers that can justify their decision to challenge a merger. The guidelines lay out a rebuttable presumption that mergers in markets concentrated above a certain level with a certain change in concentration are unlawful. And it lays out how market structure can lead to various competitive effects as indicators of competitive harm in labor markets. If the government meets its burden in laying out this prima facie case on both market structure and anti-competitive effects, then merging parties can only rebut that showing under 3 conditions. So first, that the merging or acquiring firm was basically going to fail. That's a pretty high standard. 2, that there are low barriers to entry. And or 3, that there are pro-competitive efficiencies that the parties would not achieve but for the merger. But in laying out these basic guidelines, the agency made 3 new important things in the merger guidelines, and they made these things explicit. So first, that they're just as concerned about how mergers can lessen competition for workers' labor as they are about how mergers can impact product or service markets, because mergers can lower wages, can slow wage growth, can worsen benefits or working conditions, or result in, quote, other degradations of workplace quality, right? You guys get to define what that means through your representations to the agency. What is a degradation of workplace quality that could result from a merger? Two, they would look to workers and representatives from labor organizations to provide information about, quote, among other things, wages, non-wage compensation, working conditions, the individualized needs of workers in the affected labor markets, the frictions involved in changing jobs, how hard it is to change jobs, and the industry in which they work. So they want workers' voice to understand the effects of mergers. And workers and unions are an important source of evidence explicitly identified in the guidelines for analyzing the impacts of mergers. The agencies are not just going to look at dry wage data and run regressions on that. They want to know from the ground what the real labor market effects will be, not just for working conditions, but also for workers' outside options and for worker voice. Which leads to the third point. The agencies recognize that labor markets are unique and so might justify defining labor markets narrowly, possibly even to just one firm, and might justify enforcing against mergers at lower levels of market concentration than you might when assessing mergers that impact product markets. This is because labor markets, unlike product markets, have really high switching costs, surge frictions, heterogeneous preferences, and matching costs that really limit workers' mobility and their ability to switch to other employers if the merger ends up harming them in some way. So the takeaway here is that workers and unions can absolutely help shape how the agencies view the labor market effects of mergers. And it's important when engaging with the agencies to connect the merger to ways that you think it can impact bargaining leverage over wages, benefits, or working conditions, and to think creatively about how it can degrade workplace quality. So things like control over scheduling, reduce workplace health and safety, and possibly even institutions of worker-led quality control and voice in the production process. And finally, through the merger review process, as stakeholders impacted by the merger, you can decide and advocate for a range of potential outcomes of the merger review. To block the merger, to allow the merger to proceed under certain conditions that would eliminate the anti-competitive effects on workers, or to approve the merger. And you'll have to offer reasons why, but in thinking through what conditions you might want to propose for approving a merger through what are called behavioral or conduct remedies, you can certainly include things like a neutrality agreement with the employer, right? Card check recognition, successor agreements, first contract arbitration requirements that might set a timeline for interest arbitration to reach a first collective bargaining agreement. Right, and other protections that were included in but never passed in the PRO Act and other PRO Act Plus proposals. Leave it there.
Okay, so Brian, you're up next. And as much as we all appreciate everyone's comments, I think we maybe save the clapping for the end because we're running short on time.
Except Cassie. So yeah, I mean, so I had one good example of you know how labor can play a role in educating the antitrust agencies. Going back to the last panel, which is, you know, we probably heard the term vertical restraints like 50 times today. And I remember, you know, my background's in labor, not in antitrust. And I remember the first time I sort of mentioned that in public company. I was at the Labor Research and Action Network conference in Nashville. Mariah was there. And, you know, guys, I figured out like how McDonald's can get away with this. You know, it's this antitrust thing. It's called vertical restraints. And, you know, I'm not sure it went over that well, but since then, you know, I think, you know, that term has now become, you know, people are talking about it all the time. Not that I did it. Other people in antitrust, you know, were already, you know, thinking that way. But that's something that came up sort of from the bottom up, was fed into the ears, you know, of policymakers and enforcers. And now, you know, I think it's being taken seriously. You know, I think before maybe 10 years ago, you know, vertical restraints are great. I mean, you got to keep wages down. I mean, that's the point. We don't want them to be inefficiently high. So, I think that there is sort of the educational role that labor can play. But to the issue of merger policy, so I'm going to start with an observation I think most people with labor backgrounds know, but not everyone who's an economist or works in antitrust does, is that there's no such thing as labor markets. There's only labor market institutions. I'm 99% sure that quote was from John Roger Commons, the 20th century economist, but I cannot track down the site. So if anyone knows where he said that, because I'm sure he did, so I don't want to claim credit for it. And that has important implications. So I'll start with two observations. First, as we've heard, from Josh and a bunch of people already today, the economic evidence increasingly is becoming pretty clear, much of it done by Professor Knight to my left, that employer power over wages, what economists call monopsony power, it's not some rare aberration or distortion of some otherwise perfectly competitive labor market, but it looks like it's kind of intrinsic to the employment relationship itself. Bosses have power over wages. If you worked, you probably already know that. But second thing, and I think it might seem seemingly trivial, but a crucial aspect of these labor markets is that unlike other inputs into production, like electricity or rolled steel, labor is connected to human beings who don't sell labor; they sell labor services. And I don't just mean that in like the moral sense, which is probably the most important sense, but just as a bloodless wonk. That has really important implications because workers make choices over things like they're not just attached to a productivity. I make choices about how productive I want to be. Do I go to school? Do I invest in my training? And even minute to minute, how hard do I want to work? And by the way, bosses, at least not yet, can't contract for or observe exactly how hard I'm working all the time. So that has some implications. Like for example, workers respond to different kinds of incentives, and that stuff is given by the institutional structure. So it's really those institutions that structure what wages are going to be and what productivity is going to be. And labor market institutions like occupational licensing regimes, corporate bureaucracies. I'm going to work hard today so I can get a pension tomorrow. Education, training, and apprenticeship programs, and most importantly, trade unions. These institutions sort of undergird and suffuse labor markets so thoroughly that it's really not clear what a policy to restore some perfectly competitive labor market outside of those institutions would even really mean. So, in the sort of limited, space I have here, checking the Casio, I'm going to focus on one labor market institution in particular, which is unions. And I think I want to applaud, the FTC for, I think it really has increased its sophistication of its understanding of labor markets. You could see that just the way Commissioner Bedoya was talking just a few minutes ago. And they really moved by leaps and bounds. So, in past administrations, the antitrust agencies just sort of looked at any labor market institution, and what they saw was, well, that's a distortion of competition. So, there's been this obsession with occupational licensing as the big evil, like, the hairdressers are the cartel of hairdressers is causing wage suppression in America. And even, the Obama FTC did things like they took the side of Uber against organizing workers, viewing, again, any kind of collection action. Well, that's a cartel. That's a distortion of competition. But the FTC has been improving lately. In particular, in its move to, I really encourage look at the complaint if you're interested in the merger between the grocery chains Kroger and Albertsons, because I think the FTC's analysis showed real sophistication in their understanding of labor market institutions. So workers at both chains are represented by, in most markets, are represented by the United Food and Commercial Workers Union. And in its suit, the FTC defined one of the relevant labor markets, so you have to define a relevant market, if you want to block a merger, as unionized workers specifically. And for those not deeply familiar with antitrust, merger cases turn on market definition. So, what is the product and geographic market or the labor market in which firms compete? So questions like, is Budweiser or like a craft beer in the same market? What about Budweiser and Jack Daniels? Something about the cocktail hour. Is a hospital in New Jersey, this gets more wholesome. Is a hospital in New Jersey in the same market as a hospital in Manhattan? So, the wider the market, the smaller the market shares and the more likely a merger is to get through. But, what and antitrust forces have tended to define labor markets extremely widely, viewing workers as, they're unskilled. So a retail clerk is completely interchangeable. They could go work for McDonald's tomorrow, or they work for a different grocery chain. The FTC suit really digs into and recognizes the key institutional feature of wage setting in the grocery industry, which is workers do not bargain as individuals. They bargain through a collective bargaining organization. So, whether, it's sort of, put economists out of work, but, whether, workers, you can do econometric models about what's the diversion ratio or the worker flows, or they move into different jobs, how quickly are they changing jobs? That stuff is completely irrelevant to this market, because how workers actually do bargain over wages is not by switching, it's by collectively whipsawing Kroger against Albertsons during contract negotiations. So the labor market, you don't have to do all the math. You can just look at the institutional structure of the market, and that defines the market. So the labor market is the bargaining table, period. So, rather than focus on some theoretical, perfectly competitive wage, that would prevail if the real world resembled, a blackboard where two lines go like this, the FTC confronted the actual labor market as it really exists, where workers, through their unions are exercising countervailing power that was lawfully acquired, right? I mean, so our laws encourage trade unions, this is supposed to, on paper. We've heard about how it doesn't really work that way, but those laws still exist. So in that antitrust market, any harm to workers, including unionized workers, look, that's enough. And that's, and I think that's just an example of, I'm sure they talk to the union and just, an educational process that I think has gone on, that if we keep it up, they'll keep listening.
Yeah, I think that's a really good point. Something also I want to flag is the agencies need money, right? They need resources. And so like one of the consequences of the agency is focusing on labor markets more, which is great. And there's definitely like a directive from the top and from the commission level, from like Commissioner Bedoya and I think from Chair Khan. But in order for the staff attorneys to have the time to look at both product markets, consumer effects of mergers on consumers and workers, the agencies, like, they need more people. They need more attorneys. They need, so that people aren't like, I was there when people are there on the weekend with their kids because there's too much work to be done. And that was even when there wasn't sort of adding a significant attention to the effect of mergers on labor markets. So I think Chair Khan is going to be before Congress next week, before the House Committee on Appropriations. And if people care about wanting the FTC to continue to focus and investigate the effects that mergers will have on labor, the agencies, like, they need the resources to do that. There's only so many hours in the day. So I would just encourage people to kind of support that necessary antecedent to like for this work to be done and for the agencies to be able to do the work that we want them to do and care about. Suresh.
Okay, so I actually am not really that much of an antitrust expert, and I'm sort of like proud of that. Here's why I'm sort of like, okay, so last time I was in this building was like 2 months ago, and I was debating Larry Summers, and there was like fun, we argued about lots of things, but well, basically what drove me nuts was just the conceit of the technocratic worldview that Larry Summers has, which is just that the experts understand the thing, they need to make the right policy decisions, they need to give that right policy decisions to the right bureaucrat, and then the right thing will happen. And it was like that whole worldview is just like extremely deeply undemocratic. And one of the things I like about the labor antitrust is that it brings all these people that are in democratic organizations like labor unions and makes them part of what's otherwise just another set of lawyers and another set of economists. And even in the progressive antitrust world, it's a different set of lawyers and a different set of economists, but it's still the same sort of rough technocratic communities arguing with each other. And I'm kind of not that interested to be honest. And so what I would like to think of is the idea that bringing particularly like the House of Labor into the antitrust world is a way to sort of start rebuilding it from the sort of the ground up and like taking it out of the technocratic domain and making it much more of like kind of a place where we actually can sort of start running an economy more democratically, and we can sort of do that via the competition authorities. But if that doesn't happen, then I'm like not that interested. And so
you have to be part of, part of making it happen.
Well, yes, but I can see a path where it doesn't happen, where it just goes through the agencies and it stays an agency thing. And like, that's like kind of the view of kind of like, you know, foreclose if you would say. And so I'm sort of then interested in like in the merger review process then, it's like, can we think of it as like an organizing opportunities? So it's like, what are the points in the merger review process where you can kind of bring like give like power to like a democratic labor union to kind of like give them a veto point or give them some like influence over the procedure to exercise as they see fit. And that might entail blocking mergers in some cases. It may entail the threat to block a merger in some cases. It might entail letting the merger go through in some cases. But the point is that the decision at least has some influence by the people that are like most affected by it. And that's kind of the sort of like litmus test I'm sort of after. And the other part of that is then when mergers do not have any such organization, how can the process of merger review be used to at least give those workers an opportunity to have their decision about union recognition, like actual, you know, collective representation. They might not want it. There might not be a union that fits what they want, that, you know, for all kinds of reasons, but we certainly wouldn't know in the current environment given labor law. And so can we use the anti-merger review process to kind of get around the lack of protections of organizing rights and kind of put those as kind of, okay, you know, if you imagine that a company is thinking, you know, one of the big payoffs to being a company is that we get to sell and we get to be merged. And so let's like attach some riders to that basically mean that, okay, if you're going to do that, you're not going to be able to have any outstanding ULPs. You're going to, and if you're particularly doing a big deal, maybe you do need to have all the things Hibbo was talking about, like a card check and neutrality, binding first contract arbitration, all of these things, so that you can at least like have a chance of seeing whether or not there's an opportunity for collective representation there. So I have an example. And I'll just talk about it quickly, but I'd be curious what people think about it. Like it's like Smithfield, which you've talked about in other work, which is just, you know, it's like a original non-union meatpacking firm in North Carolina. Meatpacking is great because you would never block meatpacking on the grounds of product market things because they're like nationally traded, often globalized, and so you would never block a merger on that kind of like on a product market grounds. But you look at it now, it's like the labor market for meatpacking is insanely concentrated. And so you would immediately look at that now and be like, oh, you know, you probably should have blocked that. So Smithfield then goes and acquires many both union and non-union packing plants. But then when they're acquiring the union ones, there's never any chance to let that union like expand into the non-union one. And so then instead the UFCW has multiple organizing drives in that non-union pack. And the first one is there's so many violations that like the NLRB declares like that they need to have a new election. And then that second election, there's like violence and it's just like it's a mess. And so if basically you'd had like an antitrust authority that was like, okay, the condition of Smithfield acquiring anything else is that you have to have a clean, fair union election in the non-union plant, that probably we'd have a very different union representation in the meatpacking sector, I suspect. And so I can talk more about that. I want to say two things on the labor market definition. I think that's exactly right. And one of the places where unions can be really useful is actually helping the authorities figure out what the boundaries of the labor market are really. And because yes, right now merger cases totally pivot on this labor market definitions thing. I also think on the HSR forms that he was talking about, that DOL classification, here's an interesting fact. That comes from this data set called ONET that basically everybody uses that determines the occupational classifications based on like 200 to 1,000 different factors. How do they come up with those factors? They have two methods. They first do a survey of workers, but when they can't find a worker, they have an occupational expert do it. And it turns out when you look at the answers that those two groups give, they give very different answers to a lot of things about an occupation. So the DOL has like is like this like exactly how the occupational definitions are made is actually like up in this like administrative state apparatus, and there's a real place for unions to exercise leverage there. And like, what occupational definitions are you using when you're reporting, for example? And so I'll just like conclude by sort of saying, okay, look, I know probably everyone hates economists. I hate economists. I'm a very self-hating economist. It's and I get it. But I also think if you want to sort of genuflect a little bit against the expertise that is in the antitrust authorities, bringing them into thinking about the labor market is actually like kind of a really good way to start the ideological transformation of antitrust. Because while the industrial organization economists that kind of currently run the show, they're kind of very focused on substitution as like the mechanism. So if two things are substitutes, they should not be merged. But if there's complements, they should be merged. So that's almost like all of industrial organization economics in a nutshell is that rule, which is like things that are substitutes should not be allowed to merge. Things that are complements should be allowed to merge. And so workers, if you're just competing against each other, there's like a presumption to block because you think that those workers are like substitutes. But in a world with collective bargaining and pattern bargaining and more sophisticated modes of like worker governance, you could sort of make the case that actually some mergers, because they increase the overall bargaining power of the organization, should go through because of their complements. And so then you can like make that case in very straight like neoclassical econ terms to the staff that there's a real spot for like unions and worker organizations to like let a merger go through because of this complementarity between workers when they're organized that doesn't exist when they're not organized. And I think then that forces them to figure out, okay, when are they complements, when are they not? They have to go talk to a different set of economists to do that. And those economists that they'll have to talk to will then be talking to sociologists and maybe even industrial relations scholars. And so you'll just open up the expertise that's on the table for antitrust cases, and they'll bring in a whole bunch of different sets of normative values into what can then take it away from like welfare and utilitarianism into like a different set of values that get put into antitrust. And so we can sort of start that transformation with this kind of labor thing.
Thanks. Yeah. No, I think that's really interesting. I mean, something to think about is sort of like if you're a company and you're basically like a recidivist in terms of NLRB violations, right? Union busting, like, yeah, that should maybe go on like your card as like a black mark, as like maybe you don't get the privilege of being able to buy and sell yourself, freely here. Why should you be able to get bigger and then just subject more people to your illegal conduct and more workers to that to the consequences of that? One thing to think about though is if it isn't sort of like codified or in a statute, you could certainly see what if the Republicans controlled the FTC or DOJ, like might they say, well, if there's a company that is engaging in conduct, that we don't like or hurting, a stakeholder or constituent that's important to us, we don't want that company to be able to merge or get bigger. So it is important to just think about like how, if we are going to import like some of these like more like policy judgment calls and values into merger review, how do we do it in a way that can't be
Politicized?
And I think everything, policy it involves politics, but how do we make sure, it isn't, we aren't opening the door to it being like used against us if we're not in power, or if like, the Democrats aren't in power. So I think that's more of like a process, how do we institutionalize it? Maybe other people have ideas. I haven't figured that out entirely yet. So there's been, I think, a little bit of discussion about, okay, so there's a merger and you have concerns about a merger and how it's going to impact workers. And there are some options on the table for the type of advocacy you can do. You can say, we think this merger needs to be blocked outright. So that there are more of the like independent alternatives kind of in the UFC example, so there are outside options. But you could also say, no, we want the merger to go through, and we think this is even potentially going to increase worker power if the merger is allowed to go through, but there are certain remedies in place. So I know we're running out of time a little bit, but we're going to go over a little bit because everyone else did. So we're gonna stay up here a little bit. So we want to hear, like, let's start with Hal, just about kind of thinking about, so there are these different ways to advocate for different outcomes of merger review. And is it, is it always superior to say the merger should be blocked outright? Or always, should the advocacy be that a merger should be allowed, but there should be a neutrality agreement? What are your thoughts on that?
All right, I'm going to answer that. But first, I just got to say that I'm going to be at a class certification hearing on June 17th in Connecticut involving an OPOACH case. And I'm good. When the judge asks me, what's the relevant labor market, I'm going to say, quote, labor markets don't exist. Just have taken up with Brian. I know I just blew 30 seconds on the joke, but so I think that Brian makes a good point that there are going to be cases that are distinguishable from the UFC, like the Kroger-Albertsons, in which workers aren't necessarily playing one person off another in order to extract higher salaries, but it does happen in a lot of cases. I want to just give a few very classic examples. Free agency has been studied to death, including by sports economists, and they've noticed that when workers have the ability to basically move, or mobility, I should say, instead, mobility, worker mobility, to threaten, just merely threaten to go somewhere else, they can extract large wage gains. When the Scully, famous economist, sports economist, studied what happened to Major League Baseball players when they achieved free agency, and his stats show that they went from a labor share of 15.9% of revenue in 1970-73 period to a 48.4% share of revenue in 1998 with the advent of free agency. And that's quite a big swing in the direction of workers. And I already mentioned the decline in the labor share of UFC fighters. Remember, that went from 29 to 19% after we allowed the UFC to monopolize the industry and impose, inflict these exclusionary provisions in worker contracts. So that means that in my mind, in many cases, but not all, Brian, in many cases, labor mobility made possible by free agency should be protected by all means. And that means including the antitrust law, including stopping anti-competitive mergers. And I'm talking about stopping them point blank. Now, of course, this is not to diminish the importance of the role of unions in helping workers as well. I think the answer here is that they are both helpful. I want to say that there has been, I just want to lay out one concern with behavioral remedy that you may not have heard. I know that people have been dissing on conduct remedies, right, for a lot the last decade or so, about impossible to police, impossible to monitor. Okay, you don't need to come here to get that. But I want to talk about one more downside that I think could be a vulnerability if we take the position of let's let it go through and subject it to neutrality agreements or however pro-union. And that is what scares me. I told Hippa this. I think she's got a good answer, so I'm going to set her up for this. Is the notion of mass firings after mergers, okay? And I want to give you a few examples. I just read a story in The Guardian from 2018. I had to get up to speed quickly on Luxottica and Essilor for a reporter. And I saw that when Luxottica was buying Ray-Ban from Bausch & Lomb in 1999, they were promised, that the CEO promised to save the US plants, right? And 4 months later, they shuttered them all, killing thousands of jobs in the US. UFC did something similar after it acquired Strikeforce. Of course, it didn't have to close plants, but what it did, it sat workers in a shelf and didn't give them any fights, right? And of course, if you didn't fight, you couldn't eat. But that was their version of basically restricting output. Microsoft, sorry to pick on Microsoft, if anyone's friends, immediately fired 1,900 workers after acquiring Activision. These weren't redundant, HR jobs or, support staff. These were programmers, right? And Ted Tados and I looked in the Career Builder database, and we saw that before they merged, the combined companies would control 30% of all jobs among top gaming studios in the country. Of course, giving significant switching costs between programming jobs, 30% in a labor market is very large. It's enough to suggest buying power. And I just want to give you one quote from a Time magazine article. Talked to some Activision Blizzard employees, and they said, quote, they only received significant pay increases after leaving for other companies, such as nearby rival Riot Games in Los Angeles. That again suggests to me that at least in that industry, the ability to play one employer off of another was something vital to achieve wage gains. So, and to conclude, I'm concerned about when we don't block a merger that we know is harmful to workers, that we might enhance buying power from the loss of worker mobility. But the second concern is that I'm very worried that the firm could end up engaging in mass firings before any of the behavioral remedies could even kick in. So I'll leave it at that.
Kevin, you wanna respond?
Okay, so just to plug a paper, I wrote this paper called Rethinking Breakups with the Duke Law Journal, and in it I tried to do kind of archival research on when unions intervened to propose approving mergers, blocking mergers, or conditioning mergers in agency and court proceedings. And found that there's actually a lot of diversity, surprise, surprise, between what workers think might result in a beneficial merger that could help jobs, and contexts where workers represented by unions thought that a merger could harm them, right? And so I really think it depends on the institutions in the labor market and how a merged firm could actually gain significant benefits for workers absent an alternative, right? So blocking a merger, it really depends. Blocking a merger could harm workers, but it doesn't necessarily inherently improve workers' bargaining leverage. Employers can still engage in a range of union vesting behaviors, even lawful union vesting, that will leave workers pretty badly off, even if they can switch to another union vesting employer. So labor markets being competitive can ultimately just mean a race to the bottom, where employers feel pressure to cut costs at all costs, including labor costs, and without labor market institutions that enable workers to assert some countervailing leverage against management or owners' unilateral cost cutting or organization of production, more firms competing might just give workers bad and worse outside options, right? So with a union, there are ways of actually collectively bargaining over layoffs or collectively bargaining over corporate restructuring in ways that wouldn't exist absent conditioning a merger on the promotion of worker organizing and achieving collective bargaining agreements in the first instance. And workers may benefit from mergers to the extent that they're conditioned on extending worker protections to unionize, collectively bargain, and even strike. And this is consistent with the language and the legislative history and the purpose of the Clayton and North LaGuardia Acts as some of the first federal labor and wage policies that were implemented by Congress. So I know we're short on time, so I'll leave it there, but happy to talk more in the Q&A and afterwards.
Next time, I'm gonna make sure we get the first panel slot.
Yes.
4 more minutes.
Okay, thank you. Oh, you have your thing. And does anybody over here wanna kind of weigh in on this question?
Yeah, I guess I'll weigh in real quick just to say that, I think the free agency is actually a great example because free agency comes to US sports in the context of unionization. It was the Measures McNally arbitration case that the players union filed. And free agency came with arbitration. So the union sort of set it up where they actually restricted the supply of free agents. There's only a few in a year that would set high salaries, and then the arbitrators set the lower salaries so that everyone gets sort of, a rising tide. So again, it's just the institutional structure that gives you the labor market. It's not that there are labor markets out there. No, it's not going to help you with the judge.
I'm sorry. I'll just say one thing about the layoffs. It is fairly easy to put just as a condition of the merger that the layoffs, and there's an institutional definition of major layoffs, and you can just say greater than 50% or and just say that you're not allowed to do that until the process is kind of worked out through.
Mm-hmm. Yeah, and just a real quick point, because I think we've been pretty pro-labor on this panel. I think I want to mention one challenge for labor on the issue of collective bargaining as a merger remedy, and that's something called out-of-market balancing. And this is the tough one. A harm to any relevant side of the labor market, either workers or consumers, under current law is enough to block the merger. So let's imagine Kroger was going to buy Trader Joe's, which is non-union, and they reached a deal, with unions for, for neutrality for the non-union stores. That merger could still be blocked purely on product market grounds, because you're not allowed to trade off gains to one side on harms to the other. And there's good reasons for that. And it's hard to get around this obstacle because there is an antitrust philosophy that completely embraces trading off alleged harms to one side against the other. But unfortunately, it's called consumer welfare. And the home of that philosophy is a corporate defense bar. So corporate defendants really like out-of-market balancing. You're the expert on this, Hal, because it allows out-of-market bargaining, but only as part of, sort of a screw the workers, consumer welfare ideology. I think there are a lot of, there are a lot of places, it's not going to be any mergers in any given time period. That's like a purely labor market theory of harm. These are really good. I'm sorry, I'm going off time, but yeah, that's, but it's, so it works in those cases. But as far as like a widespread thing that can like help rebuild the labor movement, I think we should be focused more on the practices, unfair methods of competition from the previous panel than merger policy. Merger policy can help here and there. Let's say Amazon's a monopolist. You're going to break up the warehouse into 5 small warehouses and like make them compete with each other. It's just, but collective bargaining does counter monopoly power everywhere. So in terms of the labor market, I still do think that's really the better way.
Yeah, I think it's kind of it's a both, right? It's an and rather than an either. I guess we're being called time. I did want to, no, it's not. We had to start late. Sure, yeah. Well, are there any questions from the audience? If not, then I am going to just usurp this last moment or two to just, we want to think about the future. We had Senator Gianaris here. He's a leader on labor and antitrust. So state legislation is a great place to look for where we can do more. And I know, merger policy isn't going to be the be all end all. It's not going to solve all the problems, but it's a real opportunity. And so I do think we shouldn't ignore it. Just real quick, policy recommendation for, if you could like very quickly, change in law, change in regulation, whether it's state or federal level, what would it be?
So inspired by Brian's last comment, I think that there should be a law that bans consideration of out-of-market efficiencies in any antitrust case, including in merger cases. So the law, if I could write it, would vacate the American Express decision right off the bat, because they were able to balance supposed gains to cardholders against the losses to merchants. And of course, the cardholders lost too, but that was hard for them to understand. It's hard to find a good economist. And then if we go back to the NCAA cases, you can see in that the kernel of the logic there was a trade-off. They were going to tolerate harms to workers. These were the athletes, college athletes who weren't paid anything in exchange for benefits to viewers with a taste for amateurism, which is a euphemism for a taste for exploitation. So I think that we have to just annihilate that mindset. The only efficiencies that would be tolerated would be those that offset the harms to the very person, the injured party. It can't be to some other party.
I'll be super quick. So labor law reform, federal job guarantee to make sure that every worker has an adequate outside option to dominant employers in a range of occupations, expanding the labor exemption to independent contractors, reestablishing standards for reviewing vertical agreements in fissured workplaces and vertically disintegrated distressed communities where capital flight and labor market conditions have enabled significant employer power, both in distressed and rural communities. So absent those big things, I think there are lots of things that could be tailored to actually boosting protections for workers through antitrust law. And that's really thinking through at the congressional level, how we want to be reviewing mergers by enabling workers to build workplace institutions through that process. So that could occur through extending a double veto on mergers to the NLRB, like it's been extended to the FCC and FERC in the context of the telecom and energy industries, but feeling that finding ways of institutionalizing workers and unions' role in providing labor inputs through having a seat at the table in merger reviews in the way that the Donnelly Act reforms have initiated and could be expanded to the federal context and across states.
All right. Burning desire to.
You have a vertical restraint, you're an employer.
You can get on board with that, Suresh.
It's full employment mandate for the central bank, actually, is my biggest antidote to labor market monopsony. It's just like running keeping the unemployment rate below like 3%. It's pretty good.
Great. Okay, we will wrap up. Thank you all for your patience, for indulging us.
I put my email up on the screen, but you can find me at Boston College if you just Google my name, and feel free to email me if you have any questions or just want to be in touch.
Thanks, everyone.
Thank you. So I'll just give some extremely brief closing comments. A couple of things that I wanted to highlight that were themes in both of the panels. One is just the need for investment in the public sector. We've really starved our public sector since the 80s. And I think that whether we're talking about labor enforcement or antitrust enforcement, that's really key. And then also, I think Suresh spoke very compellingly about sort of the need for co-governance and deep interconnection between government and civil society, and that all of this, just as labor and workplace rights are, that the whole antitrust merger review and the whole process really provides opportunity for community input and engagement. And finally, I just want to say, like, this was great. I hope all of you learned a lot. I hope it sparked some new ideas. Please join us afterward if you're able for a happy hour at the Half Pint, which is on 3rd Street. You can just Google Half Pint, and that's the right place, right, Jonathan?
Yes, it shows up as Half Pint / Ernie's Bar.
Half Pint / Ernie's Bar. For those of you who are joining us by Zoom, I'm sorry you can't join us.
Get there really fast.
And thank you to everyone. Thank you to all of the speakers and the panelists. And thank you to all of you for coming. And above all, let's just keep the conversation going and focus more than anything on opportunities to take action.